This is the Village of Corrales Governing Body Special Meeting for March 25th. I'm first going to do a call to order and Pledge of Allegiance. I'm calling the meeting to order. Let's now stand and say the Pledge of Allegiance, please. Thank you. I pledge allegiance to the flag of the United
States
of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you, everyone. I'm going to take the roll, and I will likely take it again when we move into our hearing today. But for the first time, Councilor Wolfman.
Here.
Councilor Murray.
Here.
Councilor Burkett.
Here.
Councilor Lucero.
Here.
Councilor Knight.
Here.
Councilor Parker.
Here.
Thank you very much. I'm going to ask now for the approval of the agenda. Do we have a motion to approve the agenda?
So moved.
Second?
Second.
All in favor, please signify by saying aye.
Aye.
Opposed? All right, hearing none, we've approved the agenda. The new business, we are now going to move on to item 1 under new business. This is a hearing of appeal to the governing body of Variance 21-01. My name is Joanne Roque. I'm the mayor of Corrales, and I will be functioning as the presiding officer in this hearing. The hearing today is a quasi-judicial hearing, and the decisions will be made by the members of the governing body. I'm going to conduct another roll call for the record. Councilor Lucero?
Here.
Councilor Knight?
Here.
Councilor Burkett?
Here.
Councilor Murray?
Here.
Councilor Waldman?
Here.
Councilor Parker?
Here, but Mayor Roque, just a point of order, if I may.
Yes, of course.
As I was reading through the packet for today's hearing, something became clear to me that I will need to recuse myself from this hearing because of a conflict of interest after reading some of the information that was presented in the packet itself.
Thank you very much, Councilor. We now have a preliminary matter. We may have a request for a continuance. And so before we get to the appeal, we believe that the applicant has requested a continuance. So I propose we allow the applicant's representative to present his case for the continuance, and that we then as a body rule on the request. If the continuance is granted, we are going to adjourn this matter until it is rescheduled. If the request is denied, we would then proceed with the hearing. If there's no objection, I'm going to allow the applicant to present his case for a continuance. Mr. Garrison, are you with us?
I am, Mayor, and actually we didn't request a continuance. We were curious if a continuance would be possible should certain things not be met, but we're ready to move forward today. And Mr. Gary Bennett will actually be the one presenting the main portion of the applicant's appeal today. I'm here if the folks need to talk about any of the legal mumbo jumbo we may get into, but Mr. Bennett's going to be primary here. We're ready to move forward today.
Thank you, Mr. Garrison. So I'm now going to ask the appellant to identify themselves. Mr. Bennett, you are representing the applicants today?
Yes, ma'am, I am.
And is it Denny and Crystal Frost?
Yes, Dr. Denny and Crystal Frost are the applicants,
Thank you very much.
or appellants in this case.
Right. In this case, there is no appellee. The appellant is appealing a decision of the Planning Commission. Neither the planning director nor the Planning Commission are parties. Now, today we're going to try to focus on the very narrow issue before us, which is the interpretation of the language of the ordinance. Applicant appellant is arguing that the Planning Commission made a legal error in interpreting the ordinance to prohibit their request. The merits of the case were never heard by the Planning Commission because it determined that the variance request on its face was beyond what was allowed by the ordinance. The appeal came to the council because the council is the ultimate arbiter of the meaning of its ordinances. As such, the council can decide that the appropriate interpretation of the ordinance allows for consideration of variance. I'm sorry, can you please mute yourself? I'm going to repeat that last part. As such, the council can decide that the appropriate interpretation of the ordinance allows for the consideration of variance requests like that of the applicant, or it can decide that it does not. If the council overturns the decision of the planning commission cannot appeal the decision to district court because it is not a party. It is merely a creature of the council. Thank you. As I mentioned, the scope of this appeal is going to be limited to the application for a variance related to the ordinance that disallows disturbances of 15% slope and higher in order to construct a driveway off West Ella Drive and a dwelling unit. The variance was denied by the Planning and Zoning Commission, P&Z. And the reason for the denial can be found in Exhibit C of today's packet. If people go outside of that scope, I'm going to be polite, but I am going to call you on it, and I'm going to tell you that that's irrelevant to the decision before the council today. And that goes for everyone, counselors as well, unless it is really related to the application for this variance and the P&Z's decision to deny it. We are recording this meeting this afternoon verbatim, and it's going to be creative of everything being said. Now, that having been said, we cannot create an accurate record if we're all talking over each other. So I'm going to be strict about people doing that. I'm going to stop you if you are talking over each other and ask you to go one at a time so that we can have a clean record. That's really important. The council will have the opportunity to ask questions. If you have a question, would you please say mayor first so that I will make sure that I see you, recognize you, and then allow you to speak. Again, this is really for the record, and so we can get the questions and the answers down cleanly and clearly. The questions you ask should be focused on clarifying the record or the testimony given and should not include new information or evidence being offered by a counselor through asking a question. I am also going to assume that everyone's demeanor is going to be appropriate today. There's not going to be any badgering or argumentation of witnesses, and I will probably call people out on that. As far as witnesses and evidence in this hearing is made up of everything in the record from the Planning and Zoning Department, which you all have, the P&Z hearing, and it's what is introduced for the first time here today. Evidence includes testimony and exhibits. If either party has exhibits to present, and I know there's, okay, that are not in the packet, please email them to Aaron at aggjullin@corrales-nm.org so that they may be placed on the screen for viewing. Before I give an outline of the specific process for this hearing, I'm going to turn it over to Mr. Trujillo so that he's going to give us a brief reminder of how we conduct a quasi-judicial hearing. Thank you, Mr. Trujillo.
Thank you, Madam Mayor. Can everyone hear me okay?
Mhm.
Yes, good. So this is a quasi-judicial hearing, which means that you're acting as basically a judge, a collective sort of judge in this case. So there's more formality in these sorts of hearings than in the regular hearings that we used to. That's why the mayor went into so much detail about how the hearing should be held and decorum. And that
We're having trouble.
Commission.
Mr. Trujillo,
Mayor said that the planning. Yeah.
we're having trouble hearing you, Mr.
Am I out?
Trujillo.
Am I not loud enough, or you're just not hearing
You're
me?
cutting in and out.
Well, that's the problem with the internet, I guess. Let me try again.
Okay, I can hear you now, so
Are you hearing me now?
yes.
Can everyone else? I hope.
Thumbs up, everybody.
All right, Mayor,
Yes.
Thank you.
Mayor, I'm going to be looking at your picture. So if you can't hear me, wave to me.
I will.
Let me know.
I will.
Okay, so what I was saying is I was pointing out what the mayor had said earlier with regard to the Planning and Zoning Commission's decision. They did not get to the merits of the variance. They did not get to the merits of the variance because they determined that they did not have the authority to hear it. That on its face, the request was beyond what the ordinance allowed for a variance. And therefore, they didn't go into the details of the case. So there is no real substantive record before the P&Z. What that means, I think, is that you should take this hearing and you should deal with that authority issue first. In other words, if you agree that the Planning and Zoning, but if you agree with the Planning and Zoning Commission that on its face, this request is beyond what the ordinance allows in terms of a variance, then you've made a legal determination that in essence bars the rest of this case. So the rest of the case doesn't need to be heard, and I would submit shouldn't be heard if the court determines that it doesn't, for lack of a better term, have subject matter jurisdiction to approve it. So I would suggest that the first thing you do is take up that one issue and allow counsel for the respondents to talk about that one issue, that legal issue about whether or not this is beyond the scope of the ordinance. And then the commission, in my mind, I would suggest should make a decision on that issue. If the commission decides that agrees with the Planning and Zoning Commission that it does not have the authority to grant this much of the variance, then it should, if it votes that way, the hearing's over, Planning and Zoning Commission, and decide that they do have the authority, you all decide you do have the authority to hear this request, then you could proceed with the rest of the case. But I don't want, the reason I suggest that is I don't want, if you're going to decide that you don't have the authority to hear it, doesn't make any sense to hear all the evidence and the testimony, the substantive merits of the case. So I probably spoke on a little too much, Madam Mayor, but there you have it.
Thank you very much, Mr. Trujillo. And just to clarify, what you're saying is that you are suggesting that the council first look at the language of the statute and what the Planning and Zoning Department, what the decision was, and determine whether or not they correctly interpreted the language of the statute.
That's another way of putting it.
Thank
Yes.
you. Okay. So now I'm going to tell you a little bit about the general outline of how this hearing is going to run. We are first going to have a background statement by Planning and Zoning Administrator Lori Stout. This will give the governing body an outline of the case, a review of the application, her review and what has happened before this at P&Z. The Planning and Zoning Administrator and Mr. Trujillo will then be available for questions. The applicant will then have, and I'm going to suggest that each side have about 40 minutes to present the information, and that should include or could include public input in favor of the position. I'm also going to suggest that the record itself, Exhibit G, shows a lot of public input, and so we're going to try to keep that first inquiry really on whether or not the ordinance was correctly applied or not applied. Now, the applicant may request more time if the matter being heard is extremely complicated, and upon their request, the governing body agrees with that. The applicant may present argument or call witnesses. All witnesses will be sworn in by the village clerk, Aaron Hewlin. The party can rely on the record of exhibits and witnesses from the P&Z hearing or introduce new exhibits or call new witnesses. If there are exhibits, those again should be mailed to Aaron to put on the screen. You're going to need to explain what the exhibit is. You should offer the exhibits into evidence, and if they're related to the case, they will be made part of the record. by my action unless there's an objection raised by a counselor. There can be a cross-examination of a party's witness by the other side. All cross-exam of witnesses should go through the presiding officer. Counselors or I may have questions of the witnesses, but they will be limited to clarifying the evidence, the party's arguments, or the decision of the P&Z. There will be no allowance for independent evidence, either by myself or the counselors, and I'll remind us all of that if necessary. Once both those presentations are concluded, I will close the hearing and the governing body will deliberate. This usually happens after a motion has been made and seconded, and the village council may make a decision in open session or to decide to deliberate in closed session as allowed by the Open Meetings Act. However, all decisions will be made in public. The governing body may grant the appeal and reverse the P&Z decision, may deny the appeal and affirm the decision of the P&Z, or remand the case back to P&Z if the record before us is not sufficient to ensure its decision will be in compliance with village or other governing law. Once a decision is made, then there will be a direction to our attorney, Mr. Trujillo, to prepare a written decision and findings of fact and conclusions of law, supporting the governing body's decision based on the facts established in the record. The hearing date shall be set at that time for a vote on the form of decision as soon as practicable. And after the approval of the final decision, the appeal will be concluded. Are there any questions as to the general format that we're going to be taking today?
Judge, if I may, quick question for you, a point of order. I'd like to have an opportunity to respond to Mr. Trujillo's statement as to what the authority and what the scope of the appeal is today, because I see it a little bit differently. And so I just want to make sure that you have our side's opinion as to what the actual scope of the council's authority or scope of the appeal is today. So I'm happy to do that whenever you think it's appropriate.
Mr. Trujillo, do you wish to respond before we allow Mr. Garrison to try to change the scope of the appeal?
Madam Mayor, I don't disagree with Mr. Garrison. I think he should absolutely be given an opportunity to explain why their interpretation of the ordinance is correct and why the council has the authority to hear the appeal, the substance of the appeal, and for that matter, has the ability to grant the appeal and the requested relief. I think you should have that opportunity to do that. I think what you've laid out in your process will afford that opportunity. So I think the next step is that Lori is going to say what happened. She's going to give a history of the case, say what happened at P&Z, which is in essence, they determined that they didn't have that authority. We can take questions from the council about that decision to the extent that we can enlighten them. And then Mr. Garrison will have an opportunity to speak on that one issue. And then I suggest, as I stated before, that you take up that one issue and determine whether or not you have the authority to hear this request. And then if you decide that you do, then we're going to open up the hearing again and go forward with the presentation of the applicant's case. And as Lori points out in her staff report, or you could remand this to the Planning Commission to take on that fact-finding role.
Right. So as presiding officer, I'm just going to conclude, Mr. Garrison, that you're going to have an opportunity to explain how you view the case and how you view the matter before us. I'd now like to move into the planning statement that will be given by Ms. Stout. You're muted, Councilor Knight. You're muted.
Here?
You're
Yeah,
muted.
I just wanted to bring up that I had some neighbors want to talk to me about this issue, and I told them that I could not talk about the issue. And I did get a call from Mr. Bennett, and he wanted to talk to me about the issue, and I told him I couldn't. So I just wanted to be upfront. This isn't my district. I've been on their, up towards their property on my horse years ago. I don't know what's going on with it right now, but I wanted to be open about this, and I will not recuse myself because I think I can be open and listen to the evidence. But I just wanted to make sure everybody knew that these events happened.
Thank you, Counselor Knight. I think it is an important point. I think many of the counselors may have been contacted by constituents. And I think it's important for us to be upfront that if you have engaged, I mean, generally, because we're working in a quasi-judicial realm, we should not be responding or engaging in extended conversation with people, because we are supposed to be coming here today to listen to this matter and render a decision after hearing the evidence. Anyone
Thank you, Mayor.
else, any other counselor have anything else to say? Yes, Counselor Murray.
I also have been contacted by email by constituents, and I also will have told them that I would listen to the evidence and gauge my response accordingly.
Thank you. Thank you. That's all we can really do at this point when we're trying to maintain our status as quasi-judicial people. Councilor Lucero.
I've along the same lines of Councilor Murray, I've been contacted. I've been involved in these matters for the last, forever. But I've been contacted by email and otherwise. But what I say is I will listen to the evidence in this case today.
Thank you. All right. If there is no one else, I would like to then start in with the planning statement. Oh, I missed out. Yes, I'm sorry. Bill, it's hard for me to see you. You're sitting in the dark, my friend.
Sorry. So a similar situation to the others, have been contacted and hearing the evidence. So.
All right. Thank you. Thank you very much, everyone. All right, I'm scanning everyone. Seeing no one else raising their hand, I'm going to move into Ms. Stout's planning statement.
Thank you, Mayor, councilors. And you said I have a little bit of time, yes?
You do.
Okay, thank you. I'm going to start just with a brief overview of slope enforcement in my department. I've discussed the 15% or less slope ordinance dozens and dozens of times with citizens, real estate agents, and developers. Just this week, a couple came in with their realtor looking at a lot in the Sandhills, and I advised them of the need for a topographic survey first to determine if there was both a suitable area for a driveway that was 8% slope or less and a suitable house pad site of 15% slope or less. I then discussed with them the possibility of requesting a variance if necessary for the driveway portion, and that they could request up to 1,000 square feet over 15% in a variance. This is a discussion I have with folks, I'm going to say several times a month. And it's the same discussion that I had with the applicant. Prior to meeting the applicant in person, there were some real estate agents and others who had inquired about this piece of land. I had the same discussion with them. I believe I met Mr. Frost, I want to say the end of 2018 or very early 2019. And we had that same discussion. And I did at that time say that I thought the property might be unbuildable. I suggested that perhaps they look into a contingency sale because he did want to move forward and ask for more than the 1,000 square feet allowed of more than 15%. So that's a little bit of background. The other part, I'm really just taking, I guess, from my staff summary that I gave to the Planning and Zoning Commission. And we'll just tell you about some of the relevant ordinances that apply here, especially the most important ones. But the applicants are requesting a variance to the ordinance disallowing disturbances of 15% slope and higher for two reasons. One of those is to construct a driveway off West Ella, and the other is to for part of the proposed pad site for the dwelling unit. So this request for the driveway portion is approximately 13,200 square feet of slope more than 15%. An additional 918 square feet of variance is requested for the proposed house pad site. This project takes place over 3 separate properties, so 3 pieces of land. The village code, the Article 5 terrains and stormwater management, contains the rules pertaining to slopes, stormwater and erosion control, development and grading. It starts at section 18160. 18160 is the purpose, and I wanted to mention a couple of the purposes of this ordinance. One is to ensure sound and orderly development of the natural terrain. The other is to protect life and property from the dangers of flooding and the hazard of improper cuts and fills, minimize erosion and sedimentation, minimize destruction of the natural landscape, protect the scenic character of the village of Corrales from the visual blight of indiscriminate cuts and fills and vegetation removal resulting from extensive grading and utility scars. Also to control the adverse impacts associated with accelerated stormwater runoff. So that's some of the reasons why we have this ordinance in the first place. And then in 18162 definitions, development means any man-made change in improved or unimproved real estate, including but not limited to buildings, structures, mining, dredging, filling, grading, paving, etc. We have 18164C2, private driveways shall not exceed a grade of 8%. I want to mention, because this is in my summary, at some point prior to 2004, therefore prior to the grading and drainage ordinances, someone flattened the top of a hill to try and create a building pad site, which is the building pad site being proposed here. The proposed house is at the top of that hill. In the intervening years, the village of Corrales, since I've been here, I know there are 1 or 2 times where someone, and I don't know who, was caught dumping fill on the house pad site, the proposed pad site, and also between West Ella and it. And my assumption is that was to try and create an access to it. That's my assumption. So I want to read from the actual ordinance that applies here, because it's a difference in interpretation that brings us all here. So 18164C2, natural slopes greater than 15% shall remain undisturbed. A variance may be granted upon application for isolated occurrences such as arroyo crossings and other limited areas with a natural slope greater than 15%, where the disturbance does not exceed 1,000 square feet in total. Now, the next sentence, if the applicant demonstrates to the satisfaction of the village that strict enforcement of this provision would prohibit access to the lot or placement of utilities, the commission may grant a variance. The applicants are focusing on that third sentence, which can appear to negate the maximum request allowed of 1,000 square feet of disturbance over 15% slope. I believe it's merely poorly written, and sentence 3 needs to be before sentence 2. But I did ask Mr. Trujillo for his interpretation, which can be found in the packet and which he can speak to. And he does agree with my interpretation that the intent of the ordinance is that you can ask for up to 1,000 square feet of disturbance of slope over 15%. The intent of the ordinance, in my view, was not to set a limit to what can be requested and then immediately remove that limit. And you can ask for anything. This application, again, requests a total of 14,118 square feet of disturbance over 15% slope, which is 14 times what the Village of Corrales ordinances allow. Now, that same ordinance I'm reading from goes on to say, the variance provision shall apply solely to the construction of streets, roadways, driveways, drainage ways, and utility placement, and is not intended to prevent development on natural slopes exceeding 15%. That last part, not intended to permit development, my belief is the intent is you can ask for up to 1,000 square feet for your driveway, but you may not ask for a house pad site, period. It's an isolated incident, and in this case, it's for the driveway only. So again, 918 square feet is being requested for the house pad site. Let me just look through here. So my summary basically said that I believe our ordinance and our legal counsel believes our ordinance's intent was always to be, you don't touch slopes over 15% within the village of Corrales. However, for a driveway and other limited circumstances, you may request an ordinance, a variance of up to 1,000 square feet over that 15% limit. And the applicants have asked for quite a bit more. So in this case, village ordinances simply do not allow for the extreme amount of slope over 15% that is being proposed to be disturbed. There are other items at play here too. If you look at International Building Code, which the state of New Mexico and the village of Corrales has adopted, that requires setbacks on sloped areas. So if you're to build a home on top of a hill with steep slopes, there are setbacks from the edge of that slope. And the setbacks are such that I think it would be difficult or impossible to even build a house, assuming you could get to that site because of that setback. So I had these discussions over time with the applicant and with Mr. Bennett, and the recommendation made to the Planning and Zoning Commission is that was simply too much that they were asking for, and it could not be approved.
Lori, so then would you mind explaining what happened then when you went to the planning and zoning meeting with this?
Sure. I wish I had the minutes in front of me. I've got every other piece of paper pertaining to this. But what happened was we presented our case and our interpretation of the ordinance, and very quickly the Planning and Zoning Commission decided that the word authority was used. They have the authority to listen to anything. However, they are unable to approve this, and therefore they denied it. It was outside of the scope of what they could hear. And so they denied this variance application fairly quickly.
Thank you. Mr. Trujillo, would you like to weigh in at this point?
Sure. And then I think after Mr. Garrison speaks, I may want to weigh in again.
Okay.
But I think it's important to point out that the language that's referred to, that is the crux of this case, admittedly is not well drafted. But what Mr. Garrison said at the Planning Commission meeting is basically that section is two different variances. One that is limited to 1,000 square feet disturbance, and another that has no limit. So there are two variances within that section. And what I would say is that the rest of the paragraph isn't consistent with that determination that there are two variances. When you look at the end of the paragraph, it refers to the commission may seek the advice of the village engineer in considering a request for variance under this subsection, the whole thing. And then the next sentence says, the variance provision shall apply solely to the construction of streets, roadways, driveways, drainage ways, and utility placement, and is not intended to permit development on natural slopes exceeding 15%. It refers to this variance, and it's the entire paragraph is one variance, and all those rules apply. So I agree with Lori's interpretation of the ordinance. I think it was important what she just pointed out, and that she, because during the commission meeting, she was out. I think I asked her, have you dealt with this type of variance before? And the answer was no. But I think it's important to point out that Lori deals with this language weekly and has consistently given this interpretation to her testimony today was to dozens of people. And I believe that that interpretation over time is certainly entitled to deference. And I think the Planning Commission agreed with that. And with that, I'll go ahead and close.
Thank you. I wondered if at this point, Mr. Trujillo, you think it's more appropriate for us to move over for the applicant to give his view, their view of this case, and then we can open for questions for either party, or would you rather that we do questions for you two at this time?
Madam Chair, I think it's probably well, I think you could do it either way, but I think if the council was able to hear from Mr. Garrison, I think that would probably be insightful, and then the questions can follow that.
I think that makes sense. So, Mr. Bennett, well, now I'm confused because Mr. Garrison wanted to do something, and so who am I speaking to now? I want to hear from the applicant.
Well,
Mayor, it's a little bit complicated in that the thing I was mentioning earlier was I think we have a difference of opinion as to what is actually in front of the council today. And I'd like to just take a moment to direct everyone's attention to the actual letter that listed the denial. So I believe that's Exhibit C to the package. Because I think it's important that we're all on the same page as to what is actually being considered today.
All right, let me give everybody a chance. Can everybody get to that portion of the record?
Mayor, are we talking about the Garrison Law Firm letter? Is that correct?
No.
No.
We're referring to the Village of Corrales, the denial letter. Exhibit C, page 12 of 147.
Everybody getting there? Especially because we're on Zoom, I really want to make sure that we are all on the same page, literally, Mr. Garrison.
Of course.
And so there may be some slight delays. Yes, it's a letter dated January 27th, 2021.
Yes, and I apologize. I'm used to saying yes, Judge. So if I do that, I mean,
I'm not gonna complain. It's all right. Thank you.
Can you cite the where we're at again?
We are at page 12 of 147. It is a letter
Gotcha.
on Village of Corrales letterhead dated January 27th, 2021, from Lori Stout to Mr. Bennett and Mr. and Mrs. Frost.
Thank you.
Everybody there? Okay, great. Go ahead, Mr. Garrison.
Thank you, Mayor. So first thing I'll say is I'm going to be referring, I like to give credit where credit is due. And I learned long ago that if someone has said something better than I can say it myself, to cite that person and give them the credit. I don't know Bob Borman, but he submitted a letter as part of this appeal packet that articulates a lot of the issues that we're dealing with quite beautifully, actually. So if you hear me referring to his letter, that's what I'm referring to. It starts on page 142 of the packet.
Okay.
The issue we have here is, as Mr. Borman also points out in his letter, is that the commission made a couple rulings that contradict with themselves. The first is, according to number 3 of this letter, it does not have the authority to consider or approve, not approve only, but consider. So by saying that, the commission was effectively saying we can't even hear this issue, regardless of whether it's for 1,000, 10,000, a million square feet. For some reason, the commission decided that it didn't have the authority, period, to even consider the application. In the next breath, in the next sort of statement, it says, but yet we're still going to make a decision. And that decision is that the code limits disturbance variances to 1,000 square feet. So those are contradictory. And the problem is the Frosts were not allowed to present their case, but yet there's still an opinion here that it was denied. It should have been tabled, frankly, or I'm not sure of the exact verbiage, but kicked up to the council with no decision made if the commission felt that it didn't have the authority to even consider the request. So I think that's where we have a little bit of a question as to what the actual scope is. And my argument is that the council, excuse me, has the authority to do a complete de novo hearing today and can hear the application and can hear both sides, the technical aspects, the legal aspects, and it's not limited to solely the interpretation of the statute. So what I would request respectfully is that Mr. Bennett, who is the technical expert here, to present. He has a very well thought out presentation to make. It'll probably be about 20 minutes long. I would request that the council allow him to give that presentation. Then after that, I'm happy to address a more specific issue of the interpretation of the statute to which Mr. Trujillo has already spoken today. So that's what I would request at this time, is to let Mr. Bennett give his presentation, and then we'll go on from there. I reserve maybe 5 minutes to talk about the actual legal aspect of the interpretation of the statute.
Mr. Trujillo?
Madam Mayor, a couple points. First of all, I agree with Mr. Garrison. This is the de novo hearing. And I agree with Mr. Garrison that this council can hear Mr. Bennett and can decide to approve their variance request tonight. I agree with all that. However, if this council is going to make the determination that on its face, the request is beyond what the ordinance allows to be granted, then there's no reason to hear the substantive case and then rule on it. And the reason I think that that should be taken up as a preliminary matter is I don't want for there to be allowed to put on a whole case, have a bunch of there's probably a lot of people in opposition here, have them testify as to why they think it shouldn't be. And then if the thing is going to be denied, that the waters get muddied as to why. And Mr. Garrison absolutely knows what subject matter jurisdiction is. I mean, if a court is going to determine that it doesn't have subject matter jurisdiction to grant the relief that's requested, then it's going to say that. And in essence, the requested relief is denied. That's in essence what happened below. So I think it's just semantics. But I do agree with Mr. Garrison. The council has the authority tonight to listen to the merits and substance of the appeal if they choose to, or they could take this bifurcated approach and decide whether or not on its face the request is beyond what the ordinance allows. Either way is appropriate.
All right, I'm going to suggest that it makes more logical sense to me that we look at the legal underpinning and we bifurcate it. That doesn't presume we won't get to the next inquiry if we get there, but I think it would be important for the applicant to focus right now on why they believe that there is a different legal interpretation to be had on this matter.
Understood, Mayor. I would just, for the record, just state once again that I understand the perspective of Mr. Trujillo, and I think the issue is there's been testimony today, and there's a packet in front of this council that goes well beyond statutory interpretation. And so for purposes of fairness, I think my client should be able to present the crux of their case today, regardless of whether the primary consideration is the statutory interpretation. Preliminary issue is what I should say, because there's a packet that counselors may have read before today. There's letters, there's Ms. Stout went into various things that don't relate specifically to statutory interpretation. So I feel that one side has gotten to say more about this case than the other today. So I'll just say that for the record, and then I respect the decision of the council, and I'll speak to the legal interpretation now, if that's what the council would like to do.
Thank you.
So yes, that's a, go ahead. Okay. So I think the problem is a couple things. When Ms. Stout read the statute, there was a portion of the sentence left out that I think is important. And that portion is that, let me get to it here. I apologize. I'm too using things electronically here. The last sentence that was read, so Ms. Stout ended with this, with the words, she said, the commission may grant a variance. She didn't read the rest of the sentence, which says from the terms, plural, it's important, terms, plural of the subsection that we're dealing with. The first part of statutory interpretation is that you have to give the words the meaning. You should not consider anything in a statute to be superfluous. And again, I understand where Mr. Trujillo is coming from, but I did not say or mean to infer there are two variances here. Rather, this is a tiered variance. That's not uncommon. It is not artfully worded, but you have to look at the words as they exist. And again, to cite to Mr. Borman's letter, if it's not clear on its face, you can look at historical context. And the historical context here, you know, I don't want to just read his letter. Perhaps I'd ask the commission to take one moment because he talks about statutory interpretation. And again, he said it very artfully. He had also access to information that I did not have, being a former councilman himself, as to the background of the statute. So if it's appropriate, instead of just reading what he wrote, I'd very much like the commission to take a moment and read his 3-page letter if that's appropriate. I understand I might use some of my time, but I think it's worth it.
That is a decision entirely up to you, and I don't think it's inappropriate. The letter begins at page, I believe, 140, at least in my packet.
Yes, I'm sorry. I was citing 142. I apologize. It is
That's
140
perfectly all right.
through 142. Yeah, 140 through 142. Yes, I'd like everyone to take a few minutes and read that. It's I think it's important because it gives a good historical context, which, you know, Mr. Trujillo and I can argue all day long about what what the interpretation means, but the background I think is important here. So I will mute myself until Mayor, you tell me to start talking again.
Understood. I'm really going to ask again that everybody be muted, please. All right. Has everyone, have the counselors, would you please signify by raising a thumb if you have completed reading this letter? I'm not seeing thumbs. Okay. I'm not going to rush anyone, so we're going to take the time until I see affirmative indication from all the counselors. Thank you, Councilor Murray. I've heard from Councilor Murray, Councilor Burkett, Councilor Lucero.
Whenever. All right,
Um,
thank you.
Councilor Waldman, are you still reading? You're okay? Councilor Knight? Okay, I think we have all the counselors saying that they have read the materials. Please continue, Mr. Garrison.
Thank you, Mayor. So that letter, I think, again, I don't know Mr. Bortman, but I'd like to talk to him after this is all done and see what his background is, because it's very well written, I think. But the point is, this is a tiered, the intention here was a tiered variance, where basically, if you had, the way we're looking at it is, if you had first there's the limitation, nothing over 15%. Then it goes on to say, but for limited occurrences, like in a Royal Crossing, you can get a variance for 1,000 square feet. Then, if you can prove to the satisfaction of the commission that this is going to restrict your access, make your lot unbuildable, you now have a piece of property that's worth nothing. You can't do anything with it. Then you can get a variance from the terms, plural, of this subsection. That's important. It doesn't say that it's given freely or easily. You still have to go through all the processes to prove a variance. You know, it's not injurious to the community, all the steps that, you know, the other criteria you have. Engineers are going to have to be brought in to convince the village's engineers that everything's okay. Everything that Frost did do. And again, if we're just sticking with statutory interpretation, I keep getting tempted to go further into other issues here, because I think there's been a lot of unfortunate statements made about the Frost's intentions and their knowledge that are just incorrect. But I'll bite my tongue and go back to the statutory interpretation. I don't think the intention here of the village, and I hope the intention was not to limit development. If you can engineer something to satisfy the requirements of a variance, you should be able to do so. This council has been made aware in the past, I don't know the exact date, it's in the last few years, I've become aware of a presentation that was made by the zoning P&Z to the council about this issue and the limitations of slope development, and was advised that the county of Sandoval, specifically the assistant commissioner, I believe, Makita Hill, has advised the council that this sort of limitation, saying this is it, there's no way to variance, this is the maximum, that's it, is been interpreted as a form of government taking without compensation. And that's what we're dealing with here. If you read it the way, and again, with all due respect, with Mr. Stout and Mr. Trujillo, the way they're interpreting this, you're effectively taking the Frost property from them. You're saying this is unbuildable because of the geography that exists there. We're not going to let you engineer it because it's more than 1,000 square feet. That's it. And so I think when you read that and you read the historical context and you look at this not as two different variances, but a single variance that has two parts to it, I think it's clear that what the Frosts are doing is within the scope of the interpretation of that statute. And the next step should be, okay, now that we decided that, did they do it right? Did they meet their criteria? Is the engineering solid? You're allowed to be worried about your development in your town, but you shouldn't want to have the fear that development will automatically create problems. It doesn't have to. And in certain circumstances, in this circumstance, I think it'll actually benefit things if we're able to get to that point. So I think that's all I have, Mayor.
Thank you, Mr. Garrison.
Thank you.
Mr. Bennett?
Yes, ma'am. I have probably a 15-minute narrative that's going to address from the start, including things that Planning Director Stout mentioned all the way through to Mr. Borman's letter and things that generally cover what Mr. Garrison just covered, but in its own way. So thank you that you afford me the time to do that. And I'll make it as quick as I possibly can. So with that in mind, Madam Mayor and councilors, we do thank you for the opportunity to be here today. And we would also like to acknowledge and thank Clerk Julian for the work he did in researching and assembling the documents we requested, as well as Planning and Zoning Administrator Stout for her work in this matter. It's been easy to work with them, even though we have some disagreements on some of the things. It's been a pleasant conversation from that perspective. Joining me here today, of course, is Dr. Denny and Mrs. Crystal Frost. They are the owners of the property, Robert Fierro of Fierro Engineering. Of course, you've met Mr. Garrison. And also here today is Mrs. Becky Krebs. She's the landowner adjoining the property to the east and the one who sold the lot to the north to the Frost, which abuts West Ella. Some background information before I get into the nuts and the bolts. I want to discuss some of the things that Lori Stout said, as well as a few other pieces of misinformation that seem to be circulating in recent weeks leading up to today. The applicants are quite aware of the strong feelings and opinions that have been expressed in letters and public comment. And we believe that everyone has the right and the ability to, and the opportunity to express what their concerns are. The Frost family is concerned about some of the sentiments and perceptions and want everyone to know that their intentions are not and have not been maligned. They are aware of the concerns about protecting downstream neighbors, and they want in every way to contribute the positives to the community, not to the negatives. They have been very thoughtful in their intentions and actions and appreciate the opportunity to help diffuse any misinformation. To this end, I'll give a quick background, starting with the purchase of the property on July the 2nd, 2019. In the spring of 2019, Dr. Frost and family received notice of a job relocation to New Mexico. He and his wife, Crystal, traveled to the area in search of a home or a piece of property for which to build a new home. They liked Corrales and looked for land here in the village. In late May, the appellants were shown the subject property by their relocation realtor. The Frosts were told the property was zoned agricultural A1 with rural residential as a conforming use. The lot had a road and graded area at the top of the lot to build a new home. The realtor told him it was a standard deal with no impediments known. Dr. Frost felt comfortable enough with what they were told and what he knew from his research that his family made an offer and actually purchased the property. The offer was to purchase the property. The offer was accepted and a purchase agreement was drafted subject to the usual title search and survey acceptance requirements. Their survey showed legal access to the land via Bennett Lane as represented, and the title search confirmed A1 rural residential zoning and did not otherwise show any deed restrictions, encroachments, or other encumbrances that would have alerted them to any problems with the title or building restrictions that would have prohibited them from building a home on their property. We provide this background information because of an article that was written recently in the Corrales Comment on March the 6th, alleging quotes from village officials that having warned and admonished Dr. Frost not to purchase the property prior to closing. These alleged statements are troubling to the Frost family as they never spoke with anyone at the village about this lot prior to the actual purchase of the land. Clerk Julien confirmed this in his email letter to the appellants last week, that no phone records were found to exist either to or from the village to either of the appellants' cell phones prior to the July 2nd, 2019 purchase date. The earliest email correspondences found in those records indicate a conversation and follow-up email between Dr. Frost and Administrator Stout on October the 3rd, 2019. The appellant's own phone and email research Likewise, did not find any records of a contact prior to the July closing date. Also important to this conversation is that after finding the lot, the appellants returned to their home almost immediately and did not return back to New Mexico for 6 months when Dr. Frost came back to make further arrangements for housing in November. To us, it sounds like the village was not aware of the actual purchase closing date. So without that information, there may have been an opportunity for some confusion, not knowing the precise purchase closing date had happened some 3 months earlier. One thing is certain, the Frost family, a single income, working class family with 3 children, did not ask to risk their financial future by flippantly spending over $100,000. One other important term to address in this response, and I hope it's applicable today, just as the background information, is a response to a letter from Melanie Scholler dated to the council on March the 8th. Mrs. Scholler and council, I am not the person Ms. Scholler believes me to be. I've never owned any property in this area, and I had nothing to do with any development related to Bennett Lane, nor have I ever been involved in any action with the village council related to Bennett Lane. My mother and father did own a piece of property on Bennett Lane back in the 1990s. They wanted to build a house there sometime in the 90s, but they were not able to do it. And so they sold their property sometime in the 1990s. As to the details Mrs. Scholler brings up, as to the details of the road requirements and grade elements mentioned in her letter, I do not have any history on this except to say on the surface there is some tangible misinterpretation or misunderstanding, as in the case before us today is about a driveway inside the lot boundary, not about Bennett Lane itself. Again, on the surface, these are not the same thing. Moving forward, however, today to the fall of 2020, I was contacted by Dr. Denny Frost through a reference provided by Mrs. Krebs, with whom I met some 7 or so years before. Dr. Frost and family wanted help to develop a site plan and a floor plan for a new home and assistance with the designing a suitable road that would meet the village requirements. As for my personal background, I am a contractor, a general contractor. I'm a resident citizen of the village for almost 40 years. I built many homes in Corrales, from the sand hills to the river, and we have performed many primary renovations to things such as the old post office building and the old Heritage House on Corrales Road. So we're familiar with the village, and we're here to make a positive impact. We've raised 2 children in Corrales, been involved in the PTA, the soccer club, and we are contributing vested village members. I'm not an outsider. I want to contribute positively to the village in ways that can include helping people, building homes in a quality, safe, responsible, and equitable manner. Building a quality home starts from the ground up. With a good plan and proper execution, we know it can be done responsibly, even on challenging sites. So that brings us to where we're at today. Our appeal application to the Planning and Zoning Commission, our variance application to the Planning and Zoning Commission that was slated for January the 20th contains the full articulation of where we're at and what we're trying to get done today. In short, the applicants purchased a 2.42 acre home site that has a pre-existing graded and level pad site at the top of the home site, suitable for the size and shape of their new home. The existing legal access to the home site is Bennett Lane. Bennett Lanes runs through the southeast corner of their lot and up to the building pad at the top of the home site. The existing graded driveway appears to have been in existence since the 1990s, according to aerial mapping. As installed, the driveway slope exceeds 8% maximum limit allowed by the ordinance. Accordingly, the applicant has been told this road cannot be used unless the slope can be brought into conformance. The applicant commissioned an engineering study to assess the feasibility of doing just that. In this case, the cure appears to be worse than the problem, as modification of the driveway would require more grading than the actual site. As such, the idea was abandoned. However, because this is a pre-existing driveway, the applicant is willing to use this after installing some improvements such as turf stone pavers or other such products to fully stabilize the road and to secure against erosion as the primary access to the home site, if the village will in fact allow it. As such, the applicant is asking the village for a variance to do just that. In the alternative, the applicant has contracted to purchase an additional 1 acre lot located immediately north of their primary home site. This 1 acre lot has its own legal access, West Ella Drive. The West Ella right-of-way runs through this lot along its northern boundary. An engineering plan was devised to access the home site by installing a new, fully engineered road following the natural contours of the slope to get to the home site. Installing a new road at this location puts the grade slope of the road at approximately 1.5%. The benefits of this road include the ability to provide full emergency vehicle access and turnaround at the top of West Ella. No such emergency turnaround currently exists. Combining the original 2.42 acre home site with the additional 1.05 acre lot to the north creates a combined 3.4 plus acre site for which to build one single family home. Replatting the two lots into one home site also provides two legal access points. The net beneficial effect on this aggregation of land serves to lessen the impact that would otherwise happen with building 3 homes on 3 1 acre parcels instead of building 1 home as the Frosts wish to. This seems good and beneficial to all involved, as it is 3 times less impactful than having 3 home sites. The caveat to this plan is the slope gradient of the north lot exceeds 15%. The ordinance states that soils cannot be disturbed if the grade slope exceeds that 15%. And the inability to change the 8% grade of the pre-existing Bennett driveway and the inability to build a new road from West Ella to the home site because of the grade slope limits creates an unfair catch-22 situation. This ought not be. Quality engineering and proper installation of the engineering improvements can easily meet the requirements to protect, maintain, enhance the health, safety, and general welfare of the citizens and natural environment of the village. There is no community if there are no homes, and every home makes an impact, whether old or new. Complete prohibition of construction of a new home when design methods and quality installations can overcome the challenges and the requirements of the stormwater ordinance to meet these standards should not be overlooked. Construction of a new home and roadway that create impervious surfaces but must not create a situation that causes stormwater discharge to exceed historic flows or cause uncontrolled erosion. This is clearly the understood intention of the ordinance. Unwarranted prohibition of construction is not the intention of the ordinance, as that would be discriminatory and financially harmful. Such a prohibition would create an untenable divide between the haves and the have-nots. The Frost family has, through Fierro Engineering, designed a fully engineered driveway and home pad site that meets the requirements of the ordinance. The full plans have been reviewed by village engineer Steve Grohlman. The grading and drainage and road design has been found to be satisfactory by Mr. Grohlman, as set forth in his review write-up dated, I believe, September 12th, 2020, also a part of your packet. Fortunately, within the ordinance, there is, we believe, a provision to obtain a variance to allow disturbance of soils on slopes greater than 15% for such things as roadways, driveways, utilities, and drainage ways, when the strict enforcement of the ordinance would prevent the homeowner from accessing their home site. The merits of this language for a variance appeal appear to have been the primary focus of discussion to this point. We believe the writers of the original language saw that there could be cases that would arise where the strict enforcement of that language would prevent the homeowner from accessing and otherwise enjoying the use of their property, causing financial harm as a result. A simple example is that of building a 20-foot wide road across an arroyo or low spot on your lot. If the total road length is only 50 feet long, you immediately reach the 1,000 square foot soils disturbance limits. This leaves not even enough room for the installation of utilities, ponding areas, or drainage ways. So it is welcome news to have received the public comment submission made by Mr. Borman. Mr. Borman's knowledge as a former P&Z commissioner, together with his very articulate and detailed explanation of the ordinance language governing the variance appeal, its purpose and the process, sheds much needed light on the things not otherwise easy to discern because of the confusing language of the ordinance, its provisions, and most importantly, the missing history and the obscure intent of the ordinance and its language. We ask the council to make sure note of his letter as it speaks volumes in this case. It appears there is a feeling that development of any sort that requires a variance is a negative. On the contrary, it affords the opportunity to review and direct one-off situations in a positive way. It is not a negative when the development is professionally designed and reviewed, as it is in this case, and the design positively impacts the stormwater runoff discharge limitations and provides erosion control better than what currently exists. Mr. Fierro can speak to the design about how it improves the existing runoff by staging the water discharge, which serves to mitigate flow velocity and lessen erosion. In the case we have here for the Frost family, as it is in the case we have for the Frost family, the home pad site already exists. So what we're addressing today is driveway access, utility installations, and drainage way grading. Option 1 of our variance requires the driveway to exceed 8% slope. It is not ideal, but it is something the owner is willing to do to get access to their house if the village will grant a variance to allow it. The other way, option 2 from West Ella, appears to be the best way, as it creates a new, fully designed and quality road, which provides community benefits for emergency vehicles and offers easy maintenance and overall long-term durability. As you know, we prepared a full variance application with supporting documents, including full engineering drawings, and as well as our responses to Engineer Grollman's review to the Planning and Zoning Commission for the variance hearing slated for January the 20th of this year. The commission voted to deny the application before hearing the case, as Mr. Garrison said. We believe they did have the right and the responsibility to have heard the case, and more so now for the reasons so well articulated by Mr. Bowman in his letter. Nevertheless, they voted to deny the appeal, citing they did not have jurisdictional authority or variance, which brings us before you today. There is much more to discuss, and I will do that in detail as the time comes regarding both our original application, such as the 918 square foot disturbance on the pad site and the overflow grading onto the third lot as mentioned in the staff summary. Time constraints set seemed like it would be better to be invited to speak about that at the time of the questions are asked. Other than that, we hope, Mayor Rope and council members, that we have summarized the salient points of our position and anticipate an equitable consideration of our appeal. As far as I'm concerned, this is the end of my presentation, and I'm happy to stand for those questions you may ask for myself, Mr. Garrison, Engineer Fierro, Mrs. Krebs, or anyone you wish at your discretion. And I thank you again and reserve any time that may be available to follow.
Thank you very much, Mr. Bennett. All right, I'm understanding Mr. Bennett to say that he would, at this point, rather that there are questions asked of him or his witnesses, or anyone on his behalf. Is that correct?
Yeah, if somebody has a question on something that I brought up, we're happy to address it now. Otherwise, if you'd like me to address what the 918 square feet is, I'm happy to deal with that. There's several points that I know we're going to get to. I just didn't want to overwhelm it without being in proper order.
I understand, Mr. Bennett, and I appreciate that very much. I would like to kind of, we have two separate things going on now, right, Mr. Trujillo? We have, and I do think we still need to look at the council really needs to understand what that statute means and how it's been interpreted. I appreciate the many letters in the packet. However, I would point out that we are looking at the sitting council today and the sitting planning and zoning developer director, and they have current knowledge of the matter and how it has been interpreted. There are also letters from other people who've been on planning and zoning, and they take a very different view of the interpretation of the statute. So with that, Mr. Trujillo, could you give us a little guidance as to what we might do at this time?
Well, we basically opened it up beyond the initial inquiry with what Mr. Bennett said. So I think it'd be appropriate to keep going down that path and take on If there's any questions, or if he's not done with his presentation, let him give the full presentation. And then if there are opposing views, we take whatever time Mr. Bennett took and we allow those opposing views to be heard. I mean, by doing it this way, those opposing views are going to go beyond whether the interpretation of the ordinance, but that's okay. Like I said, we could hear the whole thing and you could still make the determination that this is beyond, on its face, this is beyond what's allowed by the ordinance. But I think we've already opened up the door, and I think probably the best practices would be to have the full hearing.
All right. Well, Mr. Bennett, it's in your court.
Okay. Well, again, refer everyone back to the original application for the variance request slated for January the 20th, 2021. In that, I have basically a 16-page articulation of where we're at, but I'm going to hit, I think for both brevity and clarity purposes, there were elements, details of our variance request sat as this. Number one item, we had a request for the roadway driveway access. I've articulated that now, and I've articulated why I believe the variance process allows us to do that. The second item was the creation of a drainage way on the pad side. Administrator Stout takes that we're trying to create a pad site and it's disturbing 918 square feet of grade slope over 15% to do that, and that is not a correct interpretation. What I'm simply stating is this: if we follow the logic that we're allowed to have a variance to address specific things, the roadway, utilities, drainage ways, and things of that nature, then this follows that suit. In other words, in order to create the drainage ways, there's adequate space on the flat of the lot to build the home. In order then, once you build the home, you also have to be able to direct the water to flow towards the ponds. The 918 square feet that's being referred there refers to the grading of the top of the lot that would serve to create the drainage way. The drainage way is anything and everything related to the drainage, the hydrology, the grading plan. And that's why it was specifically pointed out that way. It was not meant to be construed as, hey, we have to do this to build the house. The flat of the lot already provides the space to build the house. All we're talking about is an extension of the grading to get the water to flow to the pond. So it follows the same element as grading the lot or digging the hole to install the utilities, to make the retaining wall, to provide the shoulders, to do all the things that the variance, that the ordinance allows for in order to complete the grading and drainage plan, but we're not asking to create more space for the house. We have that space. We just have to create the drainage ways to allow that. The second element that Mrs.
Madam Mayor, I have a question.
Yes, I'm sorry. Who is speaking?
This is
I'm
Steve
sorry,
Broder.
Mr. Broder, at this point, we're not taking public. You can't really interrupt the attorney while he's in the midst of his presentation. I think at the point when we could have some views either in opposition or support, we can do it. But I hope you understand that right now we're attempting to allow the applicant his time to give his case. Thank
Okay,
you. Thank
but you'll
you.
tell me when I can ask my question,
Yes, sir.
please. Thank you.
A second statement Administrator Stout said was something regarding the proximity of the house to the slope of the lot. This will be addressed once we get the opportunity to deal with the building permit itself, the engineering of the foundation. Fundamentally, the issue with that is that the house plan that is proposed to be constructed there has a full basement underneath the house. That full basement then intersects the slope of the lot 10 or 12 feet away from the edge of the lot. So we're actually not building on the edge of the slope because the foundation goes down almost 10 feet below the surface of the lot. So those issues are not something that are necessarily a part of the variance, but Mrs. Stout brought it up. And I want to make sure that we're not ignoring that, but that would be dealt with at the time of the building permit together with all engineered plans for the actual structure of the home.
Well, Mr. Bennett, I think you've put a good point in there. Please, can we please try to focus in on the variance request itself?
Yes, ma'am. Yes, ma'am.
Thank you.
So truthfully, Madam Mayor, I've covered the 4 points. I've covered the element of the driveway and access. I've covered the element of creating the drainage way to clarify what we're asking for in the variance with regard to the flat of the lot. And I've given 2 options that we see that we have, either using Bennett Lane and improving it the way that we can without creating additional cuts and fills, or that of what we believe is the best option, option 2, that's creating the roadway from West Ella to the lot. We believe we have the right to do that. We believe the ordinance provides for that. Anything less than that would prevent the Frost from using their lot and their at all. If I turn that over to Mr. Garrison, if he has anything to add, and again, if we need to add something specific about the engineering design that our engineer did, Mr. Fierro, or any of the things that Mr. Grolman, the village engineer, did with regard to saying that the plan was satisfactory, subject to a few things that we would have to address. I'm satisfied with what I've stated so far, ma'am.
Thank you, Mr. Bennett. And I am I want a point of clarification with Mr. Garrison. I believe with your presentation regarding your interpretation of the statute as being a 2-tier variance, that is your response to the other interpretation of this, which is that the 1,000-foot displacement is the upper limit that is allowed under this ordinance.
Correct. The way I read it is that it says basically there's step 1 and step 2 of the same variance, but they have 2 different standards and 2 different levels, so to speak, of variance or of criteria, I guess is a better way to put it. So yes, Mayor, I don't have anything else to add right now.
Thank you. I think at this point, I am going to ask, we do have some public comment, I think, and I think Mr. Brodeur, would you like to ask your or voice your opinion?
Yes, thank you, Madam Mayor. I think we just heard some new information. At the commission meeting a few weeks ago, the entire focus was on building a new driveway to the building site. And Bennett Lane was in fact judged as an inadequate access to the site. And now I think what Mr. Bennett just said a few minutes ago was that either, I was a little unclear, either both their driveway and Bennett Lane would be used to access the site, or there was still a possibility that Bennett Lane would be the only access. And the reason I'm bringing this up is because there are some restrictions on the use of Bennett Lane, even for people who own land adjacent to it, like I do. I live on Bennett Lane. In fact, I bought the lot from your parents, Mr. Bennett, back in 2002, and I built on it. And I can see the problems. It's very steep. But there is a document that was signed by all the parties entitled Declaration of Easement and Road Maintenance Agreement. And all the parties who live along Bennett Lane signed, the then current owners back in the mid-90s. And it was Bud Grady, in fact, who owned the lot, the 2.4 acre lot, prior to being sold a couple of times. So at this point, I'm not sure what to say about, I mean, this is a legal document. It was signed by the owner of the 2.4 acre lot. It may or may not have been carried along, should have been carried along with all subsequent owners. But Mr. Frost should, in fact, be a party to this. Because if he's going to use Bennett Lane, he's going to have to contribute to the maintenance of the road. And you talked about some modification to the road, and that's an entirely different thing. But just just the maintenance itself is all that this document calls out. So
Thank you.
my point,
Thank you,
point
Mr.
is
Brodeur.
that this document needs to be addressed, needs to be taken responsibility for by Mr. Frost. And that's it.
Well, and thank you, Mr. Brodeur. And I'm really going to caution again, and this is very difficult for us to do. This is why we're not trying to take new evidence, right? These are facts that are not squarely before us, that we really would need to have a different forum, I think, in order to, let's focus on what the issue is before us and not get too far afield. And I am going to look to Mr. Trujillo to help me. It's not that they're not relevant to the larger issue, but the issue before us, it does not take that into account, I don't think. And I think it's new evidence that kind of muddies the waters for us. Mr. Trujillo?
Madam Mayor, I think our ability to limit the scope of this hearing to the legal matter, the legal interpretation of that ordinance has left the barn. I think you've got, with Mr. Bennett's testimony, initial testimony, and speaking about the merits, I think that horse has left the barn. I think that we're now in the position of having a hearing on the merits of the request. So Mr. Bennett's and his representative have submitted a packet with information on their request. I didn't hear Mr. Bennett or Mr. Garrison touch on any of the factors for granting a variance, but assume that's in their packet. And the packet is replete with people with opposing views with regard to the substance of that request. So I believe that the council has before it both those arguments with regard to substance and the arguments with regard to the legal matter that I tried to bifurcate at the beginning, which is admittedly very difficult to do.
I would ask one question though, and that is, among the council's options, it has not been taken off the table that if the council should determine that there should be a substantive hearing on the variance, that it could remand back to planning and zoning for a hearing on the variance with facts that may be available to them, more facts that may be available to them rather than to this body today.
Yeah, I believe a remand is absolutely possible. Lori, I'm going to put you on the spot here. What does the ordinance say with regard to the 60-day requirement on appeal?
If I could just real quick, I don't think my client should have a problem waiving the 60-day requirement. We just want this done the right way. So whatever the issue is, I would want to talk to them about it, but
Okay.
Right.
Yeah, so basic provision of section 18-171 says the appeal shall be decided within 60 days is the date of the application of the appeal. But if Mr. Garrison and his client are willing to waive that, I think the most appropriate thing to do, if we're going to take all this testimony regarding the merits, is to remand this matter back to the Planning Commission to have a full and fair hearing.
if I may clarify, I'm not saying they are waiving it. What I'm saying is I think whatever decision the council makes today would be a decision on the appeal, which will happen within the 60 days. So I don't think we need to waive it. What I thought you were referring to is something about remanding it back, whether that would be an issue. So today a decision needs to be made one way or the other.
Well, if Mr. Garrison and I agree that a decision to remand is a decision.
I certainly think it is one of the options. I prefer, of course, for not to be that, but I can't concede that that's not an option.
I think what I'm hearing, Madam Mayor, is that if the commission were to decide to remand this matter to the Planning Commission for a full hearing on the merits of the request, that remand is a decision within the meaning of 18-171, and that would be appropriate. I think that's what I'm hearing, and that's certainly my interpretation of the ordinance.
And Mr. Trujillo, yes, the thing I would like to just clarify though is if that does happen, that would be a part and parcel of the decision that the statute does allow. I mean, I think as it's gonna be remanded, it needs to be clear that that's an interpretation saying that it does allow for more than 1,000 square feet. Otherwise, we're gonna be in the same boat again. So I think those two things have to happen together if that's going to happen.
And that makes sense. So then we're back to making that initial determination.
So I'm going to try to steer this as the presiding officer. I'm going to then try to steer us back to the underlying issue, which is whether or not this council concludes that that statute has an upper limit of 1,000 feet of soil displacement on slopes more than 15%. And I'm going to ask council to please ask questions pertaining to that issue if they wish to.
Madam Chair, if I may.
Yes.
A couple of things I just wanted to point out, and frankly, I hadn't seen the letter that Mr. Garrison, Mr. Bennett referred to. I've read it on my cell phone. But a couple of things to note with regard to that. The most interesting part of the letter is on the first page where the writer of the letter states that under a draft provision in 2005, there was going to be an ability on behalf of the engineer to grant this all-encompassing waiver beyond the 1,000 square feet. If you look at that paragraph. Couple things to point out about that. First, it's a draft. So he doesn't point to any ordinance that says that. It's a draft ordinance. And I went ahead and pulled the ordinance from 2006, and it doesn't say that. It doesn't say what the writer of this letter says it says. In fact, it almost says exactly what this says, but interestingly, it switches the order of the sentences in this section, which is really interesting. So under the 2006 version, it says natural slopes greater than 15% shall remain undisturbed. That's the same. But then the next provision says this provision shall apply solely to the construction of roads, driveways, drainage ways, and utility placement, and is not intended to permit development on natural slopes exceeding 15%. That's like the last sentence, or one of the last sentences in the current version. And then it says a variance is required for isolated occurrences such as road crossings and other sloped areas where the disturbance shall not exceed 1,000 square feet in total. And then it says, if the applicant demonstrates to the satisfaction of the village that strict enforcement of the provision would prohibit access to a lot or the placement of utilities, the commission may grant a variance from the terms of the section, of the subsection. So, subsequent to this, the writer of this letter's draft in 2005, in 2006, the ordinance doesn't say that. And I don't see that he's pointed to a previous provision to 2005 where it was ever the law that the engineer was going to be able to grant this bigger variance. That's my view of it after reading it just now, and after looking at the 2006 version of the ordinance. So I'm not sure that interpretation is of much assistance to the council.
Thank you very much, Mr. Trujillo. I'm going to take a question from Councilor Burkett.
Yep, I have just a broad question. In the terms of due process, if planning and zoning is not capable of assessing this, who is capable of assessing this appeal? I assume it's the body in front of us. So in my opinion, we have two choices: either send it back to them with the authorization of looking beyond the number scope in that particular ordinance, or solving it here because it's just going to find its way back to us. Maybe it does with more information, which could be helpful, but I would love to know, just from a due process standpoint, if they are not capable of hearing the appeal, who is?
We are.
You were the ultimate arbiter of the meaning of your statutes and your ordinances. So certainly you have that ability. And that's why we're here. So I think I agree with Mr. Garrison that I think it would be most appropriate to make that determination. It would be kind of funky to send the whole thing back down and then have them go through all that rigmarole and then maybe decide against it, have it appealed again. And then you decide, you know what, this is beyond what's allowed anyway. So Mr. Garrison's trying to avoid a big waste of time. So this is the body. One other thing I wanted to point out, though, and I think this is of note, is that if section, what is it? 162 or whatever it is,
18
the section we're talking about.
164
Thank
C2.
you. Yeah. If that provision had just stopped with the first sentence, natural slopes greater than 15% shall remain undisturbed. Is it your opinion, Mr. Garrison, that that's some sort of a takings? It would just be there's no variance. If there were no variance referred to there, what would your position be?
You're muted, Mr. Garrison.
Sorry, press the button
That's
twice.
okay.
Sorry, Your Honor. As with most statutes, I don't think it would be uncommon for it to say that, but then there would be a variance statute or variance section, which there is in this case, which explains how you can get a variance on that. So this is a little unusual, and then it has language in the actual section that delineates a variance criteria, whereas and if you look at most other of your ordinances, it will say things like you can only have private driveways to exceed 8%. But then there's a variance statute later on that says, but if you meet this criteria, you can get a variance from any of your ordinances, any zoning ordinance. So I would say no, it would not be a taking under that circumstance.
Thank you. I believe I saw a question from Councilor Murray.
Thank you, Mayor. I had to follow up on Councilor Burkett's comment too. It's my opinion that regardless of what we do, I mean, whether the ordinance is on the appeal for the 1,000 square feet, I think we're going to wind up back here if we remand it back to planning and zoning. So we might as well proceed forward. Let's take care of it and let's get it out of the way, because if we don't, we remand it back to commission, the planning and zoning commission, it winds back up here. Here's another 60 or 90 days that we have wasted the applicant's time on. And I think it's just, I think it's pursuant that we let the council take a look at this, make a determination, and then we'll see where the chips fall.
Thank you, Councilor Murray. Councilor Lucero, was your hand up? No? All right. In looking at the ordinance, I have a general question, which is that if we were to interpret it the way that the applicant suggests, would that be a large change to the way this ordinance has been interpreted and implemented?
Madam Mayor, would you like me to address that?
Yes, thank you.
Yeah, absolutely it would. Madam Mayor, councilors, I'm just going to stand by my department's interpretation of our ordinance, which the holy grail is natural slopes greater than 15% shall remain undisturbed. But you can ask for a variance on application for isolated occurrences that we've talked about for areas with a natural slope greater than 15% where the disturbance does not exceed 1,000 square feet. That's how we've interpreted it since I've been here. I can't speak to how it may have been interpreted in the past, but I feel as though it was also interpreted that way in the past. That's how I interpret it. That's how my department interprets it.
Thank you. And then I guess I have a question for Mr. Trujillo. I'm sorry, I'm getting a lot of interference. I think that Mr. Trujillo also had an opinion on the way this was interpreted and has been interpreted. And that would be different from the applicant's view. Is that correct? Am I correct in that, Mr. Trujillo?
You're correct in that. You're correct in that. I think it's of important that we know how this ordinance has been interpreted in the past. As Ms. Stout testified in the beginning, she's ever since she's been here, this is an ordinance that she interprets all the time. Apparently, everyone else, not that it matters, because they're absolutely entitled to ask for a variance, but apparently no one else has asked for a variance. That her interpretation has been the rule of law for the county for at least the 3 years or so that she's been here. And I think that's important because Ms. Stout has the expertise in this area. She's been doing it for a while. All those people that she spoke to relied on that interpretation. And I think a reviewing court would find that interpretation is entitled to some deference, especially if it's adopted by the Planning Commission as it was, and if it's adopted by you.
Thank you. And I guess I would just like to ask one more question as to what we think.
Mayor, if I may, though,
Oh,
I'd
sure.
really like an opportunity to respond.
Certainly.
Thank you. Yeah, chomping at the bit over here. So I think the issue is twofold. One, and again, this is all due respect to Mrs. Stout and Mr. Trujillo. This is what we do. We argue these points, but I would say an incorrect interpretation done for a long time is still incorrect. So the matter of the length of time that this has been interpreted incorrectly is semi-irrelevant. It doesn't mean you shouldn't stop it and change it when it is. And Ms. Stout absolutely is an expert in her field, but she's not an expert in statutory interpretation. And so the issue is whether she's applied this or not. I'm not aware of another case, and we tried to do this investigation. And I think Mr. Trujillo spoke to this. No one has tried to get this variance in the reasonable past. So this hasn't been applied to this situation. How it's been applied to other factual situations with other lots and other situations, no idea. And there's been nothing presented to this commission specifically to help with that situation, with that sort of position. So if there is someone who has applied for a variance of more than 1,000 square feet for driveway purposes, all the facts that we're dealing with here, I'd love to hear about it, but I don't think it exists. And just so, again, with all due respect, if Ms. Stout's been telling people this for a long time, she read the first part of a much longer, again, read the first part of a much longer statute, and it seems like that's where it's sort of been stuck in that first part, and the second and third part have been ignored.
Well, I think you raised statutory interpretation, and I'm sure you know that you want to harmonize the sections. So we don't want to do something where the intent of the ordinance is likely to preserve and protect from flooding and erosion. And we don't want to now interpret it so that it nullifies the rest of the ordinance. And that would be my concern.
I don't think you can find a situation, I'd be curious about this, where this change in interpretation will affect, everything else would be grandfathered in. There's no, I think that's a fear that doesn't, understandable fear, but one that really wouldn't have any application here. And if that's not the case, I'd be curious to hear about it and, argue back and forth about that a little bit.
Councilor Murray?
Thank you, Mayor. Okay, I want to ask a question about what you call the statutory interpretation, because from what Mr. Trujillo had written and giving what this basically says from most law firms, that you have to look at the entire statute. You can't limit it to just the one section that you're looking at, that you've got to take the entire statute into effect. So consequently, Article 5, which is our stormwater management plan, we have to look at that in total, do we not?
I think you could argue that things should try to be read in harmony. So I'm not sure I'm able to brief that issue, but yeah, I in general, it would be nice if things are harmonized. I guess that's a way to answer that question. I'm not sure I'm prepared to argue that fully, but yeah, I think if there's something that is in direct is contrary to the position, then that's something that needs to be considered, certainly. Is there something specific you're referring to that you think is, I wasn't sure if you were arguing on my, for our point or against our point. So I'm not sure how to approach this. So if there's something specific, a specific area
Well,
or
I
language
think
you'd like me to address.
From what I was looking at online, that it seemed to be the opinion that when you, the legislative intent, you have to look at all the words in the statute for the intent. And even though the framers of the language may be ignorant of some things, you have to take it in total. Is that not correct?
I think that is one of a many sided way to interpret things. So I don't think that's in the vacuum, but yes, that's one of many criteria that a court would look at to determine. It wouldn't necessarily be determinative, in my opinion, but it could be persuasive for one argument or the other.
I guess I would add that I don't think a court would wish to interpret a statute in a way that seemed to undermine the original legislative purpose of the statute.
Mayor Rote, please.
Yes, Councilor Bennett.
I want to speak to this just for a quick second. I believe I said in my narrative, I spoke specifically to the intent of the ordinance, and the intent of the ordinance is to protect from erosion and stormwater discharge that is dangerous or otherwise creates a compromise for anybody that's downstream, or including the homeowner. And I believe that what I was saying is that the very fact that we have solid engineering that does protect, engineering that does improve the existing, captures the stormwater, slows the velocities, and meets the intent of the ordinance, that it does not exceed historic stormwater discharge on a 100-year flood, but it takes proactive measures to employ best management standards to do that, does not at all take away from the intent of the ordinance. In fact, it works to join it together in a solid, tangible way for all homeowners within the community. So I don't think that a variance does anything to tear apart the ordinance. It simply makes it more focused, that you actually have to have a good plan. You actually have to be able to proactively address it and solve the problem. What's the problem? Is it going to flood, or is it not going to flood? And if it's not going to flood, how are you going to do that? So I just bring that up. I hope that it helps Mr. Murray as well.
Yes, Councilor Murray.
Thank you, Mayor. Well, what happens is, or what I'm thinking is this the only variance you're going to request for that particular piece of property? Because, well, if you do establish the driveway and the improvements to the pad, are you going to be disturbing the rest of the property later on?
Well, Mr. Murray, I believe you have a right to plant a garden. I believe you have a right to plant trees. I believe you have the right to use the property in conformance with the A1 zone. I believe that you have the right to do a lot of things on your property, but that's not. I don't know that we're here to address that. Nor do I know anything in the ordinance that creates a prohibition of using your property. The real issue is the OnStart. So I'm not aware of anything, but I would certainly say that the Frost family would intend to install landscaping improvements, would intend to plant some fruit trees or a vineyard, much like many other people have done. That's certainly not the point of the contention today, but I don't know that anybody could say that, no, they're never going to touch another rock on the property for the rest of their life, nor does anybody else in the village have that restriction.
Thank you, Mr. Bennett. I think I see Councilor Lucero, and then, I'm sorry, I'll get back to you, Mr. Trujillo.
And thank you, Mayor. And I'm not quite sure where this question would be directed to, either Ms. Stout or Mr. Garrison or Mr. Trujillo. And I guess I'm wanting to make sure that I got this correct in my head as far as the statutory language of 18.6, the ordinance that pertains to this. If the if the writers of this ordinance, if whoever established this ordinance deemed it 15% was the allowable grade to build on, and then went as far as to say that we're gonna allow for 1,000-foot variance for arroyos and other items. And then why would they go further and say, okay, well then, and then we can allow for anything else you guys want to build out there, when the intent was to protect against erosion and flood runoff? Why would we go as far as to go to your two-tier idea that you guys have kind of explained? Why would they do that? Why would be the intent of that? I'm not quite sure who can answer that for me, but why would they go that far?
I'm happy to address that.
The intention was to protect against erosion and flooding and the people downstream of those particular slopes. I want that answer.
Oh, sure.
I'll get
Mr.
back to you, Lori, I promise. I'm going to ask Mr. Garrison to respond.
I think it's clear, Councilman Sarah, I think it's clear in the language. The reason is an arroyo or an occasional problem does not necessarily restrict access. It can be a problem that's dealt with, but doesn't restrict access, doesn't stop you from using your land because you have an arroyo there. So the intention, as I think Mr. Borman also says in his letter, is to give a situation where if there's something that it actually says here, if the applicant demonstrates to the satisfaction of the village that strict enforcement of this provision would prohibit access, okay, so make your lot unusable, you can't use your lot. Then there's this second tier. I'm calling it a second tier because I'm not sure else how to explain it, but a second process, a second set of standards that you must go through, that you can go through, and it doesn't say it has to be approved. Understand that no one is here to say you must approve this application. If you find that it doesn't meet the standards, that's something else. But it gives you the opportunity to apply for the variance, and it gives the commission the ability to seek the advice of an engineer, determine whether your application is appropriate, and approve it based on that. That's all we're asking today, is for the opportunity to present the application and have it approved. So I think that's the reason, is it's just a matter of an arroyo, an occasional problem, or strict enforcement is going to make it so you can't use your property.
Well, I think though, it isn't, according to Council Lucero and Director Stouts, isn't a simpler view that 15% creates a lot of restrictions and a variance may be approved up to 1,000 feet? And that, because otherwise, why would the language, why would it be in there that way? I agree, it's not artful, but I think when you look at the underlying intent, it doesn't really make sense to say you could do it up to any percentage of displacement. And
if engineered properly, our argument is yes, you should be able to get a variance up to any amount if engineered properly and meets the codes and meets the satisfaction of the commission or the council members to not be injurious and meet all the other standards of a variance. Then yes, I think that you can't really say why would it be there. It's there. We can look at we've looked at the history, but it exists, and so now we have to deal with the fact that it exists. So now that it exists, how do you apply it? And the way, if it's interpreted the way Mrs. Stout and Mr. Trujillo are interpreting it, just ignore it. Just ignore the fact that it exists, or put it before the first sentence, or move it around. The problem is you're not supposed to do that. You're supposed to look at it as is and read it as is. And as is, I think it's clear that if you look at all your other ordinances, I'm not sure I've seen another one that has this language. So there's a reason this language is here. There's a reason why it says that if you can't use your property, you can seek something more than 1,000 square feet, a variance more than 1,000 square feet. That's the reasoning.
If we agree with you that that's what it says.
Well, certainly that's my argument. That's why I'm here, right? Is to make that argument.
Yeah, you're here to argue.
We're of course seeking your approval of that argument, but and I wish if I said it was automatically taken as true, but yes. And to answer your question, a simpler view is the other view, but simple doesn't mean right. I would just like to point that out. So.
Yeah, Madam Mayor, I just wanted a couple points from what the counselor said and what Mr. Garrison said, I think that are important. When you look at the language that is in this particular section, when it talks about if the applicant demonstrates to the satisfaction of the village that strict enforcement provision would prohibit yada yada, but it says all that. That language closely tracks the variance section, which is 18170. And it says where the commission finds that strict application of the requirements of this article will result in practical difficulty or unnecessary hardship that would deprive the owner of reasonable use of his land, then you can ask for a variance. It's very similar language. So all that sentence is doing is basically regurgitating what is in the variance section, right? The only thing is, so if it only said, that's why I asked Mr. Garrison earlier, if it just said there were slopes, that there was, you could get that if it said that you can't disturb a slope above 15%, and it just ended there, there was nothing else about a variance. As Mr. Garrison points out, then you could use this variance section and you could say, okay, well, I could prove all of this. But the fact of the matter is the language that he's relying on is just a regurgitation of the variance language. The only thing unique about that paragraph is the prohibition, is the 1,000 square foot limitation. So I would submit that all that language is that Mr. Garrison's relying on is basically a regurgitation of what the variance language is anyway. So the important part of that language is the standard, which is you can't disturb beyond 15%, and that the limitation to a variance is 1,000 square feet. And then you can vary it. You can get a variance, but you use the variance criteria that's in 18170. And I don't know, certainly the presentation of Mr. Bennett and Mr. Garrison have not addressed that criteria in 18170 D 1, 2, and 3. If you're going to hear them substantively, then they certainly need to address that criteria, or if they haven't addressed it, then the variance isn't appropriate.
I was going to ask.
What I have heard is a lot of other stuff. I've heard a lot of stuff with regard to the drainage is appropriate and the flooding's not going to happen and all that thing, but that's not the criteria for granting a variance.
And Mayor,
Lori, I'm going to go back to Lori first, and then I'll get back to Mr. Bennett and Mr. Garrison.
Thank you, Madam Mayor, councilors. And I want to say Councilor Lucero couldn't have said it better myself. A former village attorney said, we, the village, have a valid scientific reason for limiting slope development to 15% and less. I also happen to be a certified floodplain manager. The greatest risk to flooding in this village is not in the valley, it's on the slopes. You're all aware of the gigantic Salsa Basin project that recently finished. We have a valid scientific reason for limiting the slopes. Our West Mesa, those are sand dunes. They're subject to erosion. My department has seen a great deal of damage. In the 3 years I've been here, foundations slipping off of hills, it's valid scientific reason was enough for me.
Thank you. I'm just going to ask Mr. Trujillo again, in his role as our counselor, if what is appropriate, I think we've heard the arguments pro and con now as to interpretation of the statute. So perhaps the council would feel comfortable in making a determination on that, but we haven't, as you said, heard, and I don't know whether we should do that first. We haven't heard whether or not they could meet, frankly, the very restrictive standards that come with a variance, which is an unusual thing to grant. So what do you think, Mr. Trujillo?
Point of order, Your Honor, when we get a chance.
Sure.
We submitted
I'm still
it.
going to ask, I'll get to you, I promise, but I do want to hear from Mr. Trujillo.
Okay, fine.
Madam Chair, we're to the point, I mean, we've heard some substance on the merits of this case. And I think the best thing to do would be to allow them to put on their case. And then you could still make the determination at the end of the testimony that what they're asking for is beyond what the ordinance allows. And you could go on. Let's say that you also they put on substantive testimony with regard to the criteria for a variance, and you could decide that they don't meet that criteria too. So you could do, or you could say they meet all those things.
Okay. So I guess what we're going to do then is ask Mr. Bennett, Mr. Garrison to give a focused. We're now going to consider this to be a hearing for variance, and we're going to ask them to give substantive evidence on each one of the variance requirements. And I guess I'm going to ask Ms. Stout or you to please remind all of us what those are.
And Mayor, I would like just, when you have a moment, I would just let you know, I'd like just 1 minute to respond to Mr. Trujillo's argument a minute ago about the interpretation. That'll be the end of what I say for a while. I do need to respond to one point.
You may. Go ahead.
You're muted.
Okay, there we go. So again, Mr. Trujillo brings up a good point. He's a good lawyer. I mean, the issue is close is not the same as same. And the two portions of the ordinance he's referring to, well, you can try to call it a regurgitation. It's not. One, they do have different language. They do have different standards. One is a restriction of access. One is reasonable use. And so to classify that as a regurgitation, I think is misleading in that those are two very different standards. Okay. One is saying, yeah, the reasonable use. One is saying, you know, in this situation with the frost, they can't use it. You can't build on their property. I think that needs to really be run home again and again, is that this isn't a variance for a garden, it's a variance so they can use their property. And I think that's why there's a difference. That's all. Thank you.
Thank
Mayor.
you. All right, so are we now going to proceed into a hearing on the merits of the variance request?
That's in the application. I think Mr. Bennett can speak to all that.
First, I would like the Director Stout to explain to the council what the requirements for granting of a variance are.
Madam Mayor, Council, that's what we've been talking about all along, and my interpretation and our attorney's interpretation is that 15% slopes and above shall remain undisturbed, but that you may ask for a variance of up to 1,000 square feet of slope above 15% for some express purposes, one of which is a driveway. And so I'm sorry.
I'm looking at review process for a variance, and that's 2A. I'm on, I guess, page 21 or 22. I hope I'm in the right spot. It says conditions for a variance.
Yes, ma'am. I can address those if you'd like.
Thank you.
Yeah, Madam Mayor. So variances are addressed in section 18-170 of the village ordinances. That section is entitled variance. Subsection D under there says conditions for variance. It says where the commission finds that strict application of the requirements of this article will result in a practical difficulty or unnecessary hardship that would deprive the owner of the reasonable use of his land or building, the commission may grant a variance provided that all of the following conditions are met. So there are three conditions. Number one, the variance will not be contrary to the public interest. Number two, the variance will not adversely affect adjacent property owners or residents. And number 3, the variance is due to unique characteristics of the property that were in existence prior to the adoption of this article and that have come into existence since that time through no action of the owner. So you would have to find all 3 of those things in order to grant this variance.
Thank you.
Mhm.
All right, so I think the burden is now on the applicant to show that the variation of the article is not contrary to public interest. That
Yes,
it
ma'am.
does not adversely affect, I mean, you can do it one at a time if you wish. It's probably easier for council to follow it that way.
So in our variance application packet that we submitted ahead of the anticipated P&Z Commission hearing for the 20th of January, 2021, which is now referenced in your packet, I believe, as page number 36 and 37. We do provide the answers to those questions that you're requesting that Mr. Trujillo has made reference to. And in that, the variance of this article will not be contrary to the public interest. Our response is that the applicant has not taken any action on the subject property or road driveways to alter or otherwise create an adverse condition. The home property is in as-is condition from the time of purchase. Any improvements or installed work was done. In this case, I'd said 16 years ago. We don't know for sure when everything was done. It seems like there was some stuff done more recently, some stuff done before. Applicant has provided evidence that the strict application of the requirements of the article will result in a practical difficulty and unnecessary hardship in that will in fact serve to deprive the owner of the reasonable use of their property or their land. In other words, we can't use it because we can't get on it. The village of Corrales is a rural agricultural bedroom community and home to many thousands of residents. Applicant is seeking to build a new home for their family in alignment with the highest and best use of the land and community ideals. Building a single new home on 3.5 acres of land contributes to the rural nature of the village and is in alignment with the quality development of our community. Therefore, this variance is not contrary to the public interest. And I will add to that, that the fully engineered plans that we have that have been approved in context by engineer Grollman substantiate that by his finding that our grading and drainage plans for both the road design as well as the site are in fact satisfactory. They meet the requirements of to stop erosion, to prevent flooding, and to otherwise employ best management standards for how to deal with water runoff. And the second element, the variance will not adversely affect adjacent property owners or residents. Our response is that because the applicant intends to use the home site as a single family residence, said use will not significantly increase traffic or otherwise require unreasonable construction activities. Applicant's intended use of the home site as a single family residence is in harmony with the neighborhood and will not adversely affect neighbors' normal use or enjoyment of their land. In addition, the engineering and design improvements to be installed do not add additional water runoff to the downstream residents nor property owners. The designed improvements direct water into drainage ways and ponding areas that prevent unwanted runoff and potential for damage that can be caused by unusual storm events. Applicant is constructing one roadway and one home on one large building lot. Building of one home on 3.5 acres is significantly less impactful than what is allowable on one home per acre. The total grading disturbance area proposed is only a fraction of what may otherwise be required or allowable with 3 homes, and it's certainly less than what's allowed for the disturbance of one site. And number 3, the conditions are unique to the property, and our response is the building lot areas remaining on the west side are unique in that all lots have grade and slope elements that must be duly considered. Access to this property requires coming across the slope because no other area or possible access exists. The unquestioned legal access to the property is from West Ella right of way that runs through the applicant's land on lot 8-2B. Construction of the home is to take place on top of the lot on an existing grading area to minimize the amount of additional grading required. Positively addressing all grading and drainage requirements is unique to each of these remaining properties. An efficient design, minimal land area disturbance to meet the need for construction and access has been developed and outlined in the civil plan submittal that we've made. We believe that the variance is authorized only for lot controls and not for the use of the premises. Applicant response is that the variance request is in fact in conformance with the language of the ordinance subsection. The property is already zoned to allow single-family residential. The variance request for the grading on slopes greater than 15% deals specifically with the construction of a roadway, installation of utilities, construction of the drainage way, and other drainage controls. Applicant's variance request for both item roadway 1 or driveway access 2, which is what we're talking about off of West Ella, and creation of drainage way in the pad site are in fact consistent with the variance provision in the ordinance. That together with the packet that we submitted is in fact, I believe, does in fact address the 3 points that were requested to outline from you a moment ago.
Thank you, Mr. Bennett. Mr. Fierro,
Okay, so I just want to.
can you state who you are for us?
Yes, my
please?
name's Robert Fierro, and I'm with Fierro and Company. I'm the engineer that put together the construction plan set. So I've been doing drainage studies, 20 square miles, 18 square miles in Rio Rancho, Albuquerque area since 2006. So I just want to make the point that this development does not adversely affect downstream property owners. So I designed it where we stage the runoff, we control it by a pond. So it's like electricity, you use resistors to slow down electricity. So using a pond is slowing down the water. When you're slowing down a portion of that watershed, you're allowing the water that's not controlled by the pond to be released, and it's not joining the other watershed where the pond is getting stored. So we're mitigating the runoff and the impact on the downstream development by putting a pond and restricting that water flow and timing it where it doesn't all come down at one time. The watershed at this site is pretty small, so you're not going to have a great deal of flow coming down. So in engineering, we use science, we use physics, we use mathematics to calculate and come up a conclusion that it doesn't adversely affect the downstream.
Thank you, and I apologize. I believe since you are a witness, we should have sworn you in. Is that correct, Aaron? Mr. Trujillo? Yes.
Yes.
So we're going to have to start back from the beginning here. I'm sorry, I'm going to ask you to state your name and take an oath that the clerk will administer for you.
Okay.
Aaron?
Yeah, Mr. Fierro, if you could just state your full name and your association with this project.
My name is Robert Fierro, and I'm the engineer on record.
Great, and just to kind of rectify where we were as a witness, we'll just do it. Do you swear or affirm that everything you have already stated to this point and everything that you will state is true and nothing but the truth?
Yes.
Great, thank you so much.
Thank you, and then I think we can accept the comments that you made before as being under oath, correct?
Yes, they are.
Thank you. All right, so I think that is the case for the variance. Is there a response from the village as to the variance? The request. I can see Lori is leaning.
I'm muting. Again, all I can tell you is that I believe that we have the limits for a valid reason. And if it's the council's desire to interpret it otherwise, then so be it. I can tell you again, there has been severe flooding on the west side, and there have been issues with homes that were similarly well designed and with similar retention ponding put into place. I believe that just about anything could be properly engineered. That the question then becomes over time, is it maintained properly? This hill that the house will be built upon will suffer from erosion. Those are true statements. There's essentially an arroyo on either side of this hill that it becomes an arroyo when it rains. I mean, those are flat areas. And probably why development was not suggested on them is because they're underwater when it rains. I'm just standing for our interpretation of the ordinance, basically.
Thank you. Mr. Trujillo, do you have anything you'd like to add in relation to the variance application offered by the applicants?
No, Madam Chair, not at this time.
All right. I'm looking around and I'm wondering if at this point we have now had a hearing on the variance request. Yes, Councilor Murray?
Is there anybody else from the public that needs to be sworn in and respond?
I see someone in the right-hand corner, Patrick.
I think
You're
there's
muted.
several people who'd like to respond on both sides. I don't know if the council's planning on taking public comment, but I know there's several people from our perspective who'd like to testify.
That's fine. We will, all I will say is we're happy to hear public input. If it becomes repetitive, in other words, if someone behind you has the same point, we'll ask maybe that they simply say they agree, so that the council has a sense of that, and we don't spend too much time with people repeating themselves. But let's swear you in, okay? Aaron?
Patrick, if you could state your full name and your just state your full name for me, please.
My name is Patrick McClernon, and I live at 2968 Corrales Road.
Great, thank you. And do you swear or affirm that you'll say nothing but the truth and, the truth and nothing but the truth?
I do.
Great, thank you. Go ahead.
I don't know if it's out of order to present an opposition or whether you should continue with Mr. Garrison's people who are in support of their.
I think it's perfectly fine at this point for you to put your public comment in, Mr. McLaren.
Good. I would like to say that my response is to the material that has been submitted. There's been a lot of discussion today regarding the 1,000 square foot limit for this request and consideration by the lawyers for the applicant in the village regarding the intent and position of each sentence. I'd like to focus on the third sentence, which states, if strict enforcement of this provision would prohibit access to the lot or placement of utilities, the commission may grant a variance from the terms. The applicant has access to this lot off Bennett Lane, and he spoke to that question earlier. The Bennett Lane exists at the southeast corner of this lot, therefore access is not prohibited, and a variance under that sentence is not allowable under the sentence regarding square footage or prohibited access. The applicant's engineer presented a buildable solution, which they claim is cost prohibitive to improve Bennett Lane. Based on the requirement of reaching the northernmost highest point of the property. The applicant wants to build a conventional house on an unconventional lot. By relocating a reimagined residence in the southeast corner, they would greatly reduce the requirement for excessive cut and fill on Bennett Lane while reducing the requirement to reach the highest point. The first section in the Village of Corrales Terrains and Stormwater Management talks about the purpose, and they have several paragraphs that they think are important over this whole section, and it's to protect life and property from the dangers of flooding, to minimize erosion, to minimize destruction of the natural landscape, to control the adverse impacts associated with accelerated stormwater runoff and natural drainage ways. I think these goals would be violated and present unresolved problems with the development proposal. Historical data shows problems with development above 15% such as the damage evidenced on West Ella after the 2013 rain event. Lesser slopes received little damage. More impervious elements are added by residents over time, such as landscaping, walkways, etc., all reducing the porosity of the natural state. With the destruction of vegetation, wind quickly erodes the surface, sediment fills drainage ways, preventing engineered solutions from performing as designed due to the lack of maintenance. The P&Z Commission reviewed criteria in 2019 study to allow development on grades exceeding the 15% slope. The administration did not pursue the idea of less regulation, thus the upper limit remains unchanged. To more easily understand slope, contour lines on plans that represent typically a 1 foot change in vertical dimensions. The closer the lines are together, the greater the slope. Each of the model codes studied by P&Z recognized slopes above 15% pose significant limitations to development. Increased control and development procedures are required to protect the health, safety, and welfare of the community. This cannot be achieved by allowing private sector engineering firms, developers, contractors, and realtors alone to determine development standards. It may be to their advantage to increase their involvement without sufficient assurances of liability, coverage, or expertise. I have no reason to question the professional qualifications or performance of the engineers submitting material for this variance. SCAFCA deals with the problems inherent with fine sand and slope conditions in this area. As stated in the P&Z review, SCAFCA does not deal with the building of structures. More important, they have the defining experience in the underlying material upon which building structures are placed. They are better qualified to judge steep slope and soil erosion, and they do not recommend any building on slopes exceeding 16.7%. Buildings on slopes steeper than 16% can be accomplished, but with a lesser degree of safety, which they do not accept under their guidelines. Increasing the possibility of erosion and downstream damage is something that must be considered before approval of a variance. The village approach to avoiding liability in regard to drainage and flood control improvements should be to reduce the risk rather to increase it through more liberal policies. The defense of a design error by an engineer will not protect a government entity from liability or for injury or damage. Engineers in New Mexico do not guarantee against failure, but are held liable only for failing to provide the standard of care of fellow professionals. The P&Z study recommended evidence of financial responsibility in the event of inadequate design or maintenance. This would not protect neighbors unless the underlying elements of financial responsibility are monitored for solvency and or decreased value. Since the design criteria sets flow rates of for a 100-year storm, a design error or poor maintenance may not be tested in the short run. These issues must be vetted prior to approval of a variance, allowing any development on land deemed unbuildable by ordinance. The applicant referred to the denial of this request as taking of his property. A regulation restricting the use of property to further legitimate public ends will not be considered a taking merely because it impairs the value of the land. Courts have reasonably concluded that health, safety, or general welfare would be promoted by prohibiting uses of land. The Supreme Court has repeatedly upheld land use regulations that adversely affect real property interests. The minutes of the council meeting of October 22nd, 2019 addressed this issue.
Mr. McLaren, I'm sorry to interrupt. You are reading a letter that you have submitted in the packet. Is that correct?
That's correct.
Okay, and I'm not suggesting that it's not, it's good material. I am suggesting that I want to let people know that all of this information is before the council and they do understand it. And I understand there are a number of more pages in your letter. Would it be possible for you to refer to that letter and summarize the rest of your material?
I think I've pretty much covered the first half of it. The second portion of it that I wrote together with Mike Source addresses the rest of it. But I would like to just say that there are only two sections included in Chapter 18 that allow a request for a variance. The first, Chapter 18-164, allows disturbance for driveways that do not exceed 1,000 square feet or the condition that access is prohibited. This request involved disturbing 13 times that allowable area. The second section allows a variance request only if it meets all the requirements of that section. This cannot be demonstrated as noted further. The underlying requirements for financial responsibility, long-term maintenance do not currently exist in our ordinances. Considering all these factors, I therefore urge that this request for a variance be denied.
Thank you very much. Aaron, do we have someone else queuing up to give public input, pro or con?
I believe so. I see Mike Source raising his hand.
All right, Mr. Source?
Mr. Source, if you could unmute yourself, state your name. You're still muted, Mr. Source.
How's that?
There you go. Thank you.
There you go.
That's better. Could you state your full name, please?
Michael Source, and my address is 1800 West Law in Toronto.
Thank you. Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Please go ahead, Mr. Source.
Mayor, Council, I'd like to follow up on Pat's start there with discussion on ordinance 277, which was adopted in 1995. This property was controlled by those ordinances at that time. These were in place when this illegal grading happened, and this illegal grading has continued to happen throughout the years. Whether Mr. Frost was involved in it or the previous owners that did this, this was never permitted. This pad site, this building pad site, was created illegally without permits or grading plan. And they now claim that there is a building site on this property pre-1996, and it's been there since. This is not true. I've also included in my submittals to you pictures dating back from 4/18/19, where the supposed driveway at Ella is being created illegally. That was stopped by the building inspector who met the hauler out there and stopped them. I also submitted pictures that were dating 4/18/18 of dump trucks on this pad site where this proposed building site is, that they seem to claim has been there for many, many years. In 4/18, there was dumping going on this site to create more of this pad. Those are just two occasions that I photographed. There's been continual dumping on this site. I have lived next to this dumping site, pad site, for 30 some years. I am aware of what's going on there. And I also deal with stormwater runoff from this illegal pad site that has been created with no revegetation of the property. And this is a continual situation up here. Our comprehensive plan states the sand dunes should be maintained in a natural state with prohibitions placed on vehicular use, sand hauling, fresh dumping, and other destructive activities. Again, the enclosed material, we think a rejection of the variance request are to, we believe this should be denied. You recently had an update on the completion of improvements made by FEMA to Sagebrush Subdivision, Salsey Park. The amount of $1.4 million was spent. Sagebrush Subdivision was an engineered subdivision that failed. The private sector engineer stated that this project will solve all the problems. FEMA just spent $1 million. Let's not create another future FEMA site.
Thank you. Thank you, Mr. Source.
I probably will have other comments as this goes, but that's where I'm at right now.
Thank you. Aaron, do we have other members of the public, pro or con?
I see Jordan Webb had raised his hand in actual Zoom. And Mr. Webb, are you looking to speak to this?
Yes, please.
Okay, and then
Okay,
I
great.
see Becky Krebs, and is that Patty Flanagan? Unknown. So I'm going to ask Aaron to recognize Mr. Webb, and then Ms. Krebs, and then Patty Flanagan. Thank you.
Great. Mr. Webb, if you could state your full name, please.
Yeah, my name's Jordan Webb. I live on El Camino Campo in Corrales.
Great. And do you swear or affirm to tell the truth and nothing but the truth?
I do.
Great. Please continue.
Yeah, so I've listened to this whole process. I moved to Corrales 4 years ago, and I feel that we've put a lot of money into our property, hundreds of thousands of dollars to beautify it, to make it natural and to fit the setting of Corrales. We love the community. Our kids going to Corrales Elementary when it's open, and just really have embraced the farm town within the city feel of Corrales. In listening to this and in dealing with the city of Corrales, it sometimes can be a quite difficult village to deal with, just to be honest. But I feel that they have met the demands required from these three requirements within the variance. I know the Frost personally. They're a very kind, loving family, do not want to do any harm to the area, have fallen in love with the Albuquerque metro area. Neither of them are originally from here. She is from Southern Utah. Denny is from Arizona, and just really outstanding family. And I think that they would love to be part of the community and to follow the guidelines and develop a property that is fitting for the area and is something that all of us in Corrales want, which is a family-centered, safe community where people can raise children and just enjoy the outdoors. And so that's really all I wanted to say. And just, I think that they've met the necessities for this variance. We're talking about a driveway. We're not talking about the actual house site. I just think maybe it's a little overblown, but I can also understand the fear of, rain issues if someday we get some rain. And so, yeah, that's all I want to say. Thank you.
Thank you very much, Mr. Webb. Can we move to Becky Krebs, please? Aaron?
Yes, Ms. Krebs, would you mind stating your full name?
My name is Becky Krebs. I live at 4 Juniper Hill Road, Northeast in Albuquerque. And I am the adjacent property owner to the Frost property. And
Great, thank you. Can you, just real quick, ma'am, do you swear or affirm to tell the truth and nothing but the truth?
I do.
Great, continue, please.
All right, thank you. I own the lot to the north of the Frosts, which they intend to purchase from me in order to put this access from West Ella. I have been dealing with them for several years, have come to know Denny and Crystal. They are really conscientious people. They want to do what is correct, and they have gone completely overboard in doing the engineering required to get this done in a safe manner for the neighborhood, for the surrounding properties. They're trying to do a responsible development of the land and have been met with very many restrictions. But I do believe that they have really completed every possible tactic that could be done in order to get this project done. It will be a good and safe development for the neighborhood, including, and I do mean including, the fire access. They're planning to do a hammerhead access for fire department, which does not exist anywhere in that neighborhood. And I think that should be to their credit to understand that. So I would hope that you would consider this and approve this project, and understand that I do not believe that what they are trying to do is going to harm my property in any fashion.
Thank you, Ms. Krebs. Appreciate it. Ms. Flanagan? Aaron, you wanna get started?
Yeah. Yes, ma'am. We
you're still
cannot hear you.
muted.
I can see you speaking, but we can't hear you.
Let me do it.
I guess while we're waiting, is there anyone else who would like to speak? Oh,
Yeah, which I just had to switch computers.
All right, and I'll then get back to Mr. Broder and we'll swear him in this time. But I'm going to ask Ms. Flanagan to go first because she was getting to her computer. So thank you.
Okay.
Yes, Ms. Flanagan, can you state your full name, please?
Patricia Flanagan.
Great. And do you swear or affirm to tell the truth and nothing but the truth?
I sure do.
Great. Go ahead, Ms. Flanagan.
Mine is going to be more of an emotional comment here. I understand because all the legal ramifications have been set on the table. But living right next door, I do worry. And I think I wrote in my letter, I did write a letter there that I'm worried because we have horses down here. The sand is already coming down. And if something happens, they're stuck because they can't go anywhere. But with that said, talking to anybody about this variance, not one person was ever against the Frost family and what they want. They are more for the safety of everybody around, which is a huge issue. And my worry about the safety is, please correct me if I'm wrong, but I haven't heard one person, the engineer, the builder, the owners, and or the village talk about how are we going to keep this in the long term safe? Because that is a big issue. The Frosts get another job and they move. The new owners, are they going to be responsible for maintaining that pond? And I believe there's someone else here that could probably talk about maintenance about that, but that's our biggest concerns. Everybody wants to support as much as possible. We love this village. We want to be here, but safety is a very big issue. Thank you.
Thank you. Thank you, Ms. Flanagan. I'm going to move over to Mr. Broder and apologize that we didn't swear you in before. So we're going to do that now. Aaron?
Yes, Mr. Broder, can you state your full name, please?
Stephen Broder.
Thank you. And do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Great. Go ahead and continue. And just so you're aware, Mayor, we have a Jennifer Christensen that I'll call on next.
Thank you.
And I can summarize what I said earlier in one sentence. That I don't think that Mr. Bennett showed us a complete picture of whether Bennett Lane is going to be used for access or not. But if the final decision is to use it for access, either for building or for the residents, then we have to have a plan to repair and maintain Bennett Lane. End of sentence.
Thank you very much. Thank you very much, Mr. Brodeur. Jennifer, there you are. Thank you so much. Aaron, would you go ahead and swear Ms. Christensen in?
Yes, Madam Mayor. Would you mind stating your full name, please?
Jennifer Christensen.
Great. And do you swear or affirm to tell the truth and nothing but the truth?
I do.
Great. Go ahead.
My name's Jennifer Christensen. I live in Corrales and have lived here since 2005. I've had the privilege of raising my family here, my children here. And in knowing the Frost since they have moved here, I know that they have gone above and beyond to make sure that they are providing and building and developing the land that they own in a safe manner and in a way that would contribute to our village. They're a great family. We want them in our village. We want families like the Frosts who care about the environment, who care about the land, and who want to develop it safely to be parts of our community. I know them to be honest. I'm very disappointed that they have been slandered through this process, that there have been untrue things said about them being warned about this land. To my knowledge, they were never told prior to buying this land that it was unbuildable. As a resident of Corrales, I think that they should, the variance should be approved and they should be allowed to build responsibly on their land. Thank you.
Thank you very much for your comments. Aaron, I'm looking. Are you looking?
I am, and I don't see anyone else raising their hand at the, it's Bob Borman. Would you mind unmuting yourself, please? Mr. Borman, would you state your full name, please?
Yes, my full name is Robert Borman. I go by Bob. And my
Great, thank you. Do you swear or affirm to tell the truth and nothing but the truth?
I do affirm.
Great, go ahead, sir.
Yes, I just want to make a quick comment on the contents of the letter that I wrote. I think there's been much discussion about interpreting ordinances in their entirety. And I would say that I hope that my letter is read and interpreted in its entirety as well. My issue with the action of the Planning and Zoning Commission was that they did not hold the hearing. And that is what needed to have happened. And the fact that it is happening today, I believe this is basically what should have happened at the Planning and Zoning Commission meeting.
No, he wouldn't come out and talk to me. I talked to somebody else.
I'm sorry. I think it's Heather Ferguson. Could you mute yourself? Thank you. Go ahead, Mr. Borman.
Yes. So I think, and I won't repeat what other folks have spoken to this afternoon. But I do think that if you look at particularly on page 2 of the letter that I wrote, there are repeated references to naturally occurring lands, the slope, 15%, greater than 15%, less than 15%. To me, the key factor in considering whether or not to apply a variance for this property for the purpose of access and whether you believe that it is limited to 1,000 square feet, or whether you believe, as I do, that that there is no specific limit when it comes to the access portion. The critical consideration, I believe, that should have been for the commission and is now for you, the governing body, to decide, is whether or not what they are accessing is in fact a home site for residential purposes. And the evidence that has been entered both at the for the Planning and Zoning Commission hearing, which did not occur on the merits, but that you are hearing today, indicates that the natural terrain was disturbed without appropriate permitting. And hence, what exists now at that site is we really don't know whether there was ever a suitable portion of that property that was a home site that would not disturb 15%. I think it's important to take into account that any disturbance above 15% grade is solely for issues of infrastructure, whether it be for access or for infrastructure at the home site itself. It is not intended disturbing any property above 15% for creating a building site or for accessory buildings, swimming pools, tennis courts. None of that was intended to be disturbed above 15%. So when you take that information into hand, and nobody has presented any evidence that prior to the illegal cut and fill and dumping that occurred on that property, that there ever was a actual legitimate residential site that could be developed. I would hope that the governing body would take that into account in its deliberations in terms of whether to approve or deny the variance. I find it very, very troubling that what is being referred to as a building site, an existing building site, is not based on natural terrain. It's based on what appears to be, from the evidence presented, illegal grading that did not have a permit and did not have authorization from the Village of Corrales. So thank you very much, Madam Mayor.
Thank you, Mr. Borman. Yes, Councillor Knight. I think Councillor Knight was next on the hook, and then did you want to have Mr. Pennybaker? Is that what you're looking at?
I believe Mr. Pennybaker and as well as Ms. Frost were looking to speak as well.
All right, I think actually Councillor Knight had asked for permission to ask a question. So Councillor Knight?
Thank you, Mayor. Councilors. Yeah, my question is to Gary Bennett. I was wondering when the Frosts first looked at this property, was it the whole 3 acres that they were buying, or did they have an acre that they wanted? Did they have 2 acres? And the reason I'm asking this is to find out whether they added to their property specifically so the engineering of the runoff would occur.
Yes, so the original, Councilman Knight, the original purchase of the property was a 2.42 acre parcel. Because of difficulties in lowering the grade of the driveway from the entry of their property from Bennett Lane to the pad site, they looked for an alternate route. The alternate route had a logic to it, and the alternate route was there was a piece of property adjacent to them to the north that had the right-of-way of Westella running through it. In other words, part of the right-of-way is actually on that lot. And so the idea was to conjoin the 2 lots and to form one large lot, thereby giving them 2 legal ways of access onto the property. So I think that answers your question, but I'm not sure.
Yeah, I was wondering about if they purchased the other piece of property, not just for being able to get on their property, but for engineering purposes, for specific, I noticed in the plans, you had pipes and things, or your engineer had pipes running from the south end of the acreage to a holding pond. And I was just wondering if that was on the original property or if that was bought, so they could make sure that the runoff would be held on their property.
I believe the answer to that question is both. Number one, they didn't mind increasing the size of their property because they have a large family, or 3 children anyway, and they didn't mind having as much room to run as they could. Secondarily, the access point elevation at the top of West Ella corresponds almost flat plane between the building site pad and the roadway. So it made engineering wise an extremely easy transition to go from a height to a height without having to climb up the hill, because West Ella was already there. And in answer, I believe, to the third part of your question with regard to the piping, those are simply the drainage culverts that would be installed to direct the water from anywhere around the house or the driveway to the ponding area that's designed to be built. So either way you do it, you're still going to have storm drains, is what that would be called, directing to the pond. So I hope that answers your question.
Okay, thank you.
All right, Aaron, I think we have, next up would be, I think it's Mr. Pennybaker.
Yes,
It says Deb, but I don't believe
Not
it.
really Deb. This is Deb's
Not a
computer,
problem.
but that's
Would you
me.
mind stating your full name for the record?
Yes. John Paul Pennebaker.
Great, thank you.
John
And do
Paul
you swear
Pennebaker.
or affirm to tell the truth and nothing but the truth?
I do.
Great, go ahead, mister.
I've lived just south of where this building project is being considered. I live on Western Mesa, and I am the victim of many floods. Averaging everything from 5 to 7 years. I've been here since 1987. I'm a contractor, or was a contractor before I retired, and I've worked with architects and engineers most of my working life. And I appreciate what they do, and I appreciate how a person can have a dream about a home and building it. But I am directly in the path of these floodwaters. They do collect at a sub-basin on Reclining Acres, the road almost immediately south. And from there, they pour down. And we've done retention ponds. I've had 2 engineers here in 2013, who made some suggestions, but they were all things like paving the road and so forth. That would have been impossible for all the members on the road to agree to do anything like that. So we're kind of stuck with whatever waters do run on those, and that's exactly where they come from. They come from over on West Ella and Western, the next road down. I just want that to be the big consideration is, and I'm not wanting to rain on anyone's parade exactly, because I know the efforts that have gone into building a house. I've done that myself, and but the city's going to have to take hold of this in a way that addresses the problem directly. Is this a problem? If it is a problem, let's not have it. Simple as that. That's about all I've got to say. Thank you.
Thank you very much, Mr. Pennybaker. I appreciate it. Aaron, or Ms. Frost, is she on the, she wishing to speak?
She just turned her camera off. We'll see if she's there. Miss Frost, are you still there with us? Doesn't seem like it at the moment.
I know she's
maybe
trying
if
to
she
manage,
comes
I know
back.
she's trying to manage 3 kids, so it may
All right.
just take a second. to bring it back.
Sure.
Okay, and then I do want to mention that I'm trying to let everyone who wants to speak, but we're not necessarily going to let people speak more than once. Once we feel that we've gotten the substance of people's comments, pro and con. And I appreciate that. I think the sun is going down. And so I think once we feel we've gotten the measure of the comments, we will want to move on probably to either a closing statements or deliberations. So
And it does,
Madam
it
Mayor,
does look like,
Madam Mayor, and I also think it's appropriate. First of all, absolutely, this isn't a turnstile where you get to talk again and again and again as a member of the public. One time is absolutely the norm in these instances. But I think you should probably, at some point, close comment from the floor. So we draw a line in the sand where we're not going to hear from anyone other than staff or the council.
All right, that's fine. I think we are waiting for Ms. Frost.
and it does, I was just saying, it does look like she's not in the meeting anymore. She may be having some sort of connectivity issue or something. I will keep an eye out if she rejoins, but it does look at this point that she's not in the meeting.
Her battery died on her device and she's trying to reconnect. So you might look
Okay,
for her to
and
come back in the
in the
meeting.
meantime, I believe that Mr. Source said he wasn't quite finished, so I'm going to cut him a special deal.
okay.
Allow you to finish your comment. All right, Mr. Source?
Thank you very much. I just want to make one comment under oath. I have lived here long before that pad was created. There was no building pad naturally. This was formed illegally by the property owner at the time, who was Bud Grady. There was never a natural building pad on this site. What they're claiming is a building site was made illegally with no permits. Thank you.
Thank you, Mr. Source. Have we gotten Ms. Frost on any device?
It does not look like yet. I do see Becky Krebs also raising her hand again.
All right, well, I'll allow it, and then I'm going to say that's the end unless we can hear from Ms. Frost, and then we're not going to hear any more public comment. So, Ms. Krebs?
Yes, thank you very much.
You're welcome.
I agree exactly with Mr. Source, who said Bud Grady created that pad site, probably illegally. I don't know, because it was done prior to 1999, which is when my husband and I acquired our land.
Okay.
So it was done a very long time ago. I doubt that he had permits. However, I also want to address the illegal dumping issue. Mr. Source has pictures of trucks dumping debris, dirt, whatever on my land. That was done without permission. And indeed, it was done by the prior owner of Mr. Frost's property. And his name is Greg Peralta. He did that without my permission. And I have not been able to get Mr. Peralta to respond to my emails or my letters. So that had nothing to do with the Frosts. It had nothing to do with me. Neither of us had anything to do with the dumping to create any sort of artificial roadway.
Thank you, Ms. Krebs. Appreciate your candor and your information. All right. At this point, I'm looking at it. We have been at this for 3 hours. And I.
Madam Mayor, just really quickly, Ms. Frost was able to join us.
All right.
If you want to get her and have that be the last comment.
Yes, the final comment. Thank you.
Great. Ms. Frost, would you state your full name for the record?
Yes, my name's Crystal Frost.
Great, thank you. And do you swear or affirm to tell the truth and nothing but the truth?
Yes, sir.
Great, go ahead, Ms. Frost.
Okay, I wanted to address two things. Becky addressed part of it, that anything illegal happened before we bought it. And those illegal activities were not disclosed to us when we purchased the property. We had no idea, and Becky told us. Also, I really appreciate all of the comments made by citizens of Corrales and neighbors for and against the variance. I like understanding what my neighbors' concerns are, and I wanted to let you all know that it's really, really important to us that your concerns and your worries about the property are addressed. So I just wanted to get that out there, how important that is to me.
Thank you very much, Ms. Frost. I appreciate it. I'm now going to close public comment. At this point, I think it's not necessarily called for in my script. We could actually entertain a motion that could be made and seconded to go into deliberations, absent a short statement by anyone, if it's absolutely necessary, if somebody feels they do not understand the facts before us. Councilor Murray, did I see your hand?
Yes, thank you, Mayor. Councilors, I would move to deny variance request 2101.
I think that we need to deliberate that actually as a body, Councilor Murray. So
Do we? I mean, I thought you said we'd make a motion and then deliberate.
Right, we're going to make a determination. So we could do this in an open session, or we could do it in closed session. Does the council have a preference?
Madam Chair.
Councilor Knight?
Madam Chair.
Yes.
You do have a, whether I don't know what the intent was, but you do have a motion on the floor. So the appropriate thing to do now would be to see if there's a second for the motion.
Okay. Is there a second to deny this request for variance? Councilor Waldman?
Yes, I'll second that.
Okay, so I have a motion on the floor to deny and a second. So I'm now going to take a vote of the council, a roll call vote, all right?
Well, now, are we going to deliberate? I mean, this.
Madam Chair, this is council. I think it would be appropriate now to deliberate with regard to the motion that's seconded.
And again, I have my question. Is everyone comfortable with deliberating in public here, in open?
I am.
All right. Then
I mean, ask the rest of the council, but I am.
So we have a motion and a second, and now we're going to have a discussion or deliberation in this case.
Mayor,
Yes,
may I go
Councilor
first?
Knight?
I'll
Mayor,
get my
I would like
comments
to
out of the way.
make a motion to deliberate in private.
Okay. Do I have a second for that?
Madam Chair, I'm so sorry.
That's okay.
You've got a motion and a second deliberation on that motion. You can't have another motion.
Right.
Mr. Murray could withdraw his motion and the seconder can agree to withdraw, and then we can allow Ms. Knight to make a motion.
Okay.
I will withdraw my motion then.
I'll withdraw my second.
Well, I'm going to keep mine. I would like to deliberate with and listen to my other colleagues.
Do I have a second?
I'll second that.
To close. All right. So I now have a second and a motion to close under the exceptions to the Open Meeting Act. And should I just take a vote on this, Mr. Trujillo, at this point, or?
Well, just to be clear, so what we're doing is we're taking a vote on whether or not to go into closed session under,
That's correct.
would be section 10:15:1.
Oh, that's correct. I
Page-
understand
page
how to
3.
close the meeting. I understand
Yeah.
how to close the meeting. I
Very
just-
good.
am
That's
I-
right.
All right. Is it all right if I do that now then? Or do you want me
Yes.
to? All right. Okay, so the meeting of the governing body now intends to go into closed session pursuant to exceptions under MNSA 1978, section 10:15:1, section H3. We will now requires a majority vote of a quorum of the governing body. So I believe I already have a motion and a second to close. So I will now take a vote by a roll call vote. William Waldman,
Aye.
Stuart Murray,
Aye.
Zachary Burkett,
Aye.
Kevin Lucero.
Aye.
Aye.
All right, and of course, Councilor Parker has recused himself. So at this point, I believe we will be redirected to a different meeting room. I want to explain that nothing will be decided in the meeting, and we will only discuss the item before us, and then we will come back out into open meeting and announce, make a decision. All right. So Aaron, can you put us into a different room?
Yes, Madam Mayor, I'm working on that now, and I just had a question for council. Mr. Trujillo, since Mr. Councilor Parker has recused himself, he is not eligible to be in the closed session, correct?
Correct.
Okay, great. So that it should put everyone in the correct room, and we will work through it. So thank you. Just be patient. I'm just finishing up now. If you'll give me 1 second.
Thank you. And I have to say, as the presiding official, I'm going to take a very short break. I'll be right back. And I would recommend if anybody else needs to do that, now would be a good time. Thank you, everyone.
Does anybody know what those of us in the peanut gallery are supposed to be doing?
Not a clue, Mr. Borman, not a clue.
Okay.
Check your email.
I'm sorry?
You can check your email while you're waiting.
No, I mean, do we just stay where we are? Is that the?
You can just hang out, or you can leave and try to gamble getting back in time, or just hang out.
Okay, thank you. I'm new at this, so.
I keep getting a request to join the breakout room. What is that?
That is actually not for you, Mr. Bennett, because that is where we'll be deliberating. I mean, not that you wouldn't be welcome on some level, but it should just be the council, the governing body,
Okay.
and our attorney there. Sorry.
Mayor,
All right, well-
Mayor Rowe, I think it went out to everyone to join that breakout room. Oh, she's gone.
Yeah, that was why I asked, because I thought maybe the breakout room was like sort of a, R&R for those of us in the peanut gallery. Maybe
That's
you
what I was
would
wondering
have,
if there was
refreshments and
popcorn.
games or something.
Exactly.
No.
All right, I'm waiting for the public. I guess the public has re-entered the room. We don't have to physically wait for them to enter. They're already here.
Well, Madam Mayor, actually, if you would wait another 20 seconds,
Certainly.
some people don't click the button to join, so they'll all automatically join in about 15 seconds. If
Well,
you,
then
if
we're
you don't
just
mind
gonna,
waiting just a
or
little bit.
no, we're gonna wait for them. And then I want to tell the counselors we're going to take a roll call vote to reopen the meeting. And then I will announce it's reopened, and I will just say what we, that we only discussed things that were specified in our motion for closure, okay? But we're gonna wait for everybody to rejoin.
And it looks like we've done that now, so you can proceed, Madam Mayor.
All right, thank you so much. All right, the public has re-entered the room. I'm going to take a roll call vote to reopen the meeting. Counselor Waldman,
Aye.
Counselor Murray,
Aye.
Counselor Burkett,
Aye.
Counselor Lucero,
Aye.
Counselor Knight.
Aye.
All right, the meeting is now reopened. I want to emphasize that the matters discussed in the closed meeting were limited only to those matters specified in the motion for closure. And this statement as to that effect will be approved as part of the minutes under section 1015(1)G. So at this point, we can go ahead and take action. Do I have a motion? Yes, Counselor Murray.
Thank you, Mayor and councilors. I move that we deny variance 2101 for failure to meet the criteria of the variance and for exceeding the 1,000-foot maximum allowed.
Do I have a second?
Second.
All right, Counselor Waldman. All right, I'm going to take a roll call vote on this matter. Counselor Waldman,
Aye.
Counselor Murray,
Aye.
Counselor Burkett,
Aye.
Counselor Lucero,
Aye.
Counselor Knight.
Aye.
All right, the council has now made a decision, and I'm going to direct our counsel, Philip Trujillo, to prepare findings, conclusions, and decisions of the governing body. This document is going to be prepared. Hello, I lost my last page after all this, so close. It's going to be prepared and it will be brought back before this body for confirmation at a future council meeting. Do I have any other comments from our attorney, Mr. Trujillo? As to that session, when do you propose that those findings will be available to us?
When is your next meeting?
Our next meeting will be April 11th, I believe.
They'll be ready for the April 11th
Okay.
meeting if you want to do it then.
I guess it's actually April 13th. So we will confirm this vote and will be voted on the date, which is April 13th. All right. So I think at this point we have concluded our meeting and I will accept a motion to adjourn.
So moved.
Second.
Thank you very much. I want to thank all members of the public and the applicants for a thorough meeting and exfoliation of everything regarding this. Thank you so much, everyone. I appreciate it. Good night.
Thank you, Mayor.
Thank you, Mayor.
Bye, Mayor.
Good night.